잠시 안내 말씀드리겠습니다.
Ladies and gentlemen, I would like to make a short announcement. The conference will begin at 10 o'clock. This conference is being held as a non-contact remote conference due to the spread of COVID-19. Viewers would be able to join us through YouTube, and this conference will be streamed live online via YouTube. Please tune in to the Seoul City channel for Korean, and the service will also be streamed in English, so please tune in your language of preference. And also, we will be providing both Korean, English, and sign language interpretation for this conference. And also, since the conference is being held remotely, we will be collecting questions through the chat box. So if you have any questions, please make sure to ask them by typing in them in the chat box. And we'll be also holding a event for the viewers. If you take a selfie of yourself watching the conference and upload the photo with a hashtag on social media, we will be able to select 100 winners to whom we will be presenting a coffee coupon, and you will be able to check out the link through the QR code. So I'll see you at 10 o'clock. Distinguished guests, good morning. Welcome to the 2020 Seoul Human Rights Conference. Thank you so much, everyone, for taking time out of your busy schedule and joining us both offline and online. I would also like to thank our speakers and all of our guests today. I am your moderator today, Park Sun-young. This year marks the 5th year of the Seoul Human Rights Conference. And this year's theme is Human Rights in Crises and the Role of the Seoul Metropolitan Government. We have gathered domestic and international experts to discuss in the general session, the special session, and the theme sessions, respectively, through 1 through 3. However, unfortunately, this year, due to the spread of COVID-19, we have decided to hold a non-contact online conference. It is very regretful that we cannot meet you in person. However, we are still connected online, and all of our audience can be here with us today on YouTube. Please bear with us till the end of the conference. This conference is being live streamed on YouTube. For Korean, please tune in to the YouTube Seoul channel, and for English to the Seoul City Government official channel. Make sure to select the language of your preference. And also, for people with disabilities, we are providing sign language interpretation for this conference as well. We are servicing the conference, and we will be collecting Q&A. We have collected the questions in advance from those who have been provided a link, and since the conference is being conducted online, we will not be collecting questions on the site, but if you type them in on the chat box, the moderator will ask them on your behalf to the speakers. And as I mentioned earlier, we will be holding a small event where if you take a picture of yourself watching the conference and upload the picture on social media with a hashtag attached to it, after the event is over, we will be selecting 100 winners and give them a coffee coupon. For more details, please refer to the official website of SHRC or scan the QR code on the screen. So we had the opening ceremony yesterday, and today we will be having the general sessions where we will be discussing many hopeful messages in these testing times. Furthermore, I would like you to note that the site, the venue, has been disinfected this morning, and we are in line with the government's preventive guidelines. All the speakers and the moderators will be wearing a mask, so we would like to ask for your understanding even if there are some difficulties regarding the audio. So with that, I would like to begin the first general session under the theme Universal Birth Registration System and Human Rights. In this session, we will be discussing the Universal Birth Registration System and human rights, and also ways to make sure that all children's birth is registered regardless of their nationality, and subsequently that their human rights are all protected. So I would like to introduce the moderator of session number 1, Kim Jeannie, foreign attorney at Duru Association for Public Interest Law. Ms. Kim will be moderating the first session for us. Ms. Kim is currently working as an attorney at law at the Duru Association for Public Interest Law. With that, I would like to hand over the floor to Ms. Kim. Nice to meet you, ladies and gentlemen. As introduced, my name is Kim Jeannie. I am currently working at an association that is committed to building a universal birth registration system for children. I am very honored to be the moderator for the first session, and I understand that there are audience that are joining us online. I would like to send out a hello to all of them. We will be listening to 3 presentations, followed by a panel discussion and a Q&A session. Allow me to introduce all of the speakers. First of all, we have Mr. Ma Han-or, attorney at the Toru Association for Public Interest Law. Next, we have Associate Professor Hyun So-hee, who's an associate professor at the 성균관 University.
그리고 마지막으로 현재 벨기에에서 지금
And last but not least, we have Liana Keith from PICUM, Platform for International Cooperation on Undocumented Migrants, who are joining us from Belgium. And then we have our panelists today. First of all, we have Lee Jin-young, Deputy Director from the Human Rights of Women and Children Division from the Ministry of Justice. We have Hong Ju-hyun, Deputy Director from the National Court Administration. We also have researcher Song Hyo-jin from the Korean Women's Development Institute. And we also have Director Park Byung-soo from the Child Rights Division of the National Human Rights Commission of Korea. With that, we'll go straight into the first presentation delivered by Mr. Ma Han-or from the Toru Association for Public Interest Law. He is currently working at the Toru Association mainly regarding children and adolescents, and he's also working alongside me in the Universal Birth Registration Network. So, Mr. Ma, whenever you're ready, you can go present at the podium over there.
Good morning, good afternoon, and good evening. I am Ma Han-or. I'm an attorney at Toru Association for Public Interest Law. The attorney Kim Jin has introduced the Universal Birth Registration Network, and I'm working for the network as well. Universal Birth Registration Network is working hard for the introduction of the Universal Birth Registration System, and we are working with child welfare organizations and experts in legal systems, and we are doing a lot of campaigns or any legal advice as well. In June, we had a very welcoming ruling by the Supreme Court. Sorry. Today, first of all, I'd like to talk about the birth registration system, and I'd like to talk about the introduction of the current birth notification system and universal birth registration system, and I'll explain some cases, and then there will be conclusion. First off, I'd like to talk about the current birth registration system in Korea. As I mentioned, the Supreme Court issued a very welcoming ruling for the first time in Korea. They recognized the birth registration rights in relation to the unmarried woman's birth registration. The Supreme Court ruled that in modern society, in order for an individual to use the state-run system, they must have social status, such as resident registration, and acquisition of social status begins with the birth registration of the individual. And it also ruled that birth registration rights should be given to all children. Also, even in the UN Convention on the Rights of the Child, child's birth should be registered right after the birth, which confirms the rights for birth registration. Birth registration is not just a confirmation or a record or approval of the birth of a child. It is related to the rights to education, social service, and medical care. So it is the starting point for all public services. Also, the illegal adoption, kidnapping, or child abuse can be prevented through this birth registration, as it's a safety net to prevent all of that. The child can also be recognized for its identity and is the first step to recognize their rights. So universal registration introduction is being promoted by the International Society, and since the 2011 UN Committee on the Rights of the Child establishment, it has recommended the introduction of birth registration system. But the current birth registration system in Korea is not satisfying such recommendation. First off, if you see the current system, the parents are obliged to report the birth of a child, and it only relies on the obligation of parents. There is a fine or the notice of urge. So there is some enforcement measures under the current law, but before the system recognizes the birth of a child, such enforcement measure cannot be really effective. And the system for unmarried women's birth registration still has many obstacles. This year, fortunately, as I mentioned, the ruling by the Supreme Court has expanded the scope. But before, unless the child is proven to be completely cut off from the birth mother, it was difficult to prove the birth registration. Also, the birth registration was not allowed for a child whose nationality cannot be confirmed. This means not just a child with a foreign nationality. Even when the child is certain to have a Korean nationality, if that cannot be confirmed or proven, then the birth registration cannot be made. If such right is infringed, then the rights cannot be provided or guaranteed, and the child is exposed to crime. I'd like to talk about some cases that we came across at our network. First off, is about the child A, and the child was born prematurely at the hospital and needed some treatment. The only record we could obtain was the name of the mother, who was supposed to be a Vietnamese, but we couldn't really know if that was the name of the mother or father exactly, and we couldn't know the nationality of the parents exactly. And at the time, the child care facility was raising the child, and they couldn't really register the child because of the uncertain nationality. The second case was a child born between a Korean mother and a foreign father, and the Korean mother disappeared. And because of a disease, the child needed regular treatment, and the child also needed to go to elementary school the year after. But before the preparation of all of that, the birth registration was not made. The third case is when both parents were foreign nationals. The problem was that the legal record for the father was completely erased, so the embassy of the father's home country did not allow the father to make birth registration. Also, unfortunately, the child died of the leukemia before the bone marrow transplantation. They didn't take the birth registration, but they accepted a death report at the embassy. The child was born in Korea and lived in Korea for 10 years, and then went to school even with the friends in Korea. But there was no record whatsoever in Korea to remember the existence of the child. The fourth case was that the biological mother, was neutralized to Korean. And after the neutralization, the mother tried to report the birth again. And then at the time of the birth, the mother was a foreign national, and then she couldn't make a registration in Korea. The embassy also told her that she couldn't make registration because she was neutralized to Korean, so she couldn't make a registration in both countries. So that was a long, detailed explanation on the cases, but let's speed up a bit. I'd like to talk about the birth notification system. As of now, 99.5% of children born in Korea are born in Korea, and the rest of the children are born outside of hospital. So the medical institutions, if they can report the birth for the 99.5% children, then the government can use some measures to enforce the birth registration. In the beginning of this year, there was a full-scale investigation into the children under the age of 3, and some children were found to be dead and buried without any registration. And there were some children in 2018 and 17 when the children were not registered properly or registered falsely for the benefits. And recently, we found a dead body of a 2-month-old baby that was not registered, and the body was found in a fridge. So this was a huge controversy. The current system relies on the voluntary registration by those who are obliged for registration. So this cannot fully guarantee the rights of children. So that's the limitation of the current system. As I mentioned earlier, if someone neglects the rights, the obligation, then the head of the region can impose any penalties or enforce the registration. If that is the case, then the municipality of the head of the municipality can enforce the registration. But unless those who are obliged for registration do not come out and say that I have not registered my children's birth, then there is no enforcement measures. In May 2019, there was new measures for the birth registration system, and the government announced the introduction of the birth notification system. May last year, even the Ministry of Justice made a similar recommendation. But the case of a child that was found dead without any registration, as I mentioned, and then there was another case where the dead body of a baby was found in a fridge. But despite all of this, the government has not come up with any additional measures. And the lawmaker Shin Dong-gun proposed a bill to the National Assembly to enforce medical institutions to make registration, but the National Assembly has not made any progress on the bill. With the introduction of the birth notification system, there are two proposals that I'd like to make. First of all, not in addition to the notification by the medical institution of the birth registration to the local governments also should have a stronger authority and the right to make a birth registration. The current regulation is mainly discretionary. As I mentioned, the head of the government and local government can make a birth registration. In some cases, I believe that their obligation should be enhanced to state that they must make a registration. With the universal birth registration system, we have to make sure that immigrant children is not excluded, and we need additional measures and the facilities. The screen that you are seeing now is birth registration-related regulations that our network has prepared with many different lawyers. Next, unmarried women's birth registration. I mentioned about the Supreme Court ruling. So it does recognize the children's rights for birth registration. Also, for the name, the identity, and resident registration number of the birth mother should be known according to the interpretation of the court. If the part of the information cannot be known, or if the mother has not provided the documents without any reason, and if there is any reason that the mother cannot be responsible for, in all of these cases, the unmarried mother can make a birth registration. So there was a slight change to the law. At the 21st National Assembly, some lawmakers have proposed a bill. Lawmaker Nam In-sun and Seo Young-kyo proposed to the change of the Article 46 of the law to include the father and the mother as to be obliged for the birth registration. And before the name, the basis of registration and resident registration of the biological mother should be known, and that information, only the part of the information can be known for the birth registration. So that's a proposed amendment to the bill. Examples by the Supreme Court were reflected in the amendment of the law. There was also provision related to the birth registration by the unmarried father, and that provision has been deleted. And according to the new bill, the unmarried father has been added to the list of the people obliged for the birth registration. There are many concerns because of the presumption of paternity in the civil law, because this could be in conflict, conflicting with the birth registration rights. When the child is born, it is clear to see the maternity relation. And when you're trying to decide who the father is, the spouse of the biological mother at the time of the birth is presumed to be the biological father. This presumption of paternity, when the time the science was not developed, was determined as a means to decide who the father is. Nowadays, there is a DNA testing or a more scientific development, so there is a possibility. We should open up the possibility to overturn the presumption of paternity. But others argue that presumption of paternity is a strict rule according to civil law, so we should be more cautious. So, in addition to the scientific evidence, if the paternity relationship is not been established or is completely destroyed, maybe we can overturn the presumption according to some opinions. As you've seen, you can see here, we have come up with some amendment to the laws at the Universal Birth Registration Network. Lastly, Universal Birth Registration System. The current Korean birth registration system is related to the Act on Registration of Family Relations. The Article 1 of this Act is to do with the birth, marriage, and the death of the citizens, and it also stipulates the birth of citizens. So those of you who do not have the Korean nationality, it is difficult for them to make birth registration according to this act. The government also has a special report system to allow people to register the birth of children at the local governments and prove their birth with the birth certificate. But if you see the essence of the birth registration, then this is not enough. The birth registration system is to confirm and record the birth of a child. And based on the public ledger, the government should prove the birth of the children. That's the essence of the birth registration system. But for the special report only proves the receipt of the report, but it does not actually confirm the actual birth of the child. Some would argue that the children can be reported for birth at the mission of foreign countries, but there are also limitations. As you've seen at the case 3, if the birth mother is neutralized, then she could not really make a registration in either of the countries. When an unmarried mother is not recognized in the home country, then, or if the mission of the country is not in Korea, also the undocumented immigrants or the refugees have some limitations in visiting the embassy of their home countries. So universal birth registration and the birth registration for all children, there are 3 measures that we can realize this. First of all, we can apply the birth registration under the Act on the Family Relations to all children. The second measure is that in the Registration of Family Relation Act, we can have a separate birth register for immigrant children. Thirdly, we can have a separate system only for immigrant children. But to have a separate regulations or separate birth register for immigrant children, I believe that in terms of the procedures and content, it could be discriminatory for immigrant children. And the Act on Registration of Family Relations has overall regulations and provisions, and we can utilize this. Additionally, as I mentioned, many children who do not have the Korean nationality need to be registered for birth. So undocumented children need to be registered through the visit to the local governments, and we can exempt them from the rights, the obligation to report at the local governments. If the parents are the undocumented immigrants, it doesn't mean that we should call the children as undocumented. The rights of the children should be guaranteed as an individual rights. When we talk about the children without any birth registration, many people say, oh, that's unfortunate and that's sad. But this is not just sad or unfortunate. It's the story of people who are living in the same era with us. This is not just a story of children that cannot be helped. This is a story of us, and this is about our attitude in terms of how we are going to accept them. This is also to do with the realization of basic rights. And those people who have to rely on their personal decisions for the guarantee of their basic rights. And the basic rights is something that should be given to everyone, and many people are experiencing the infringement of basic rights. To provide basic rights to children, to all children, I'd like to ask for your continued interest. Thank you. Thank you very much, Attorney Mahanal, for a good presentation. For children's right, he talked about the need for a universal birth registration system. He also talked about the limitation of the current birth registration, focusing on many different examples and cases. He also talked about the need for the introduction of the birth registration system and any improvement for the current laws, also any amendment that are being prepared by the network. Also, he talked about the universal birth registration system. So he talked about and explained about the need for a change of our view. Next, the second presenter is the Associate Professor Hyuns from Seoul University Law School. She is an expert in family law in relation to the birth registration rights of the children. She's providing advice as well. The professor will talk about the need for a universal birth registration system. The floor is yours, please.
Hello, my name is Hyun So-hee. I'm an associate professor at Seoul University. The topic of my presentation actually may overlap significantly from the previous presentation, since we're dealing with the same subject of universal birth registration. The contents are quite similar, but I was worried that you may be too bored if I cover all the same details, so I would try and highlight some different topics. You have just been briefed about the 2020-575 verdict, where the Supreme Court acknowledged the child's right to be registered at birth. It was a landmark decision that carried significance. In this case, there was a Korean father and a foreign mother and a child that was born out of wedlock. So in this case, if a child is born under a Korean company, since the father is of a Korean nationality, according to Korean law, the child should also have a Korean nationality. But if the child was born out of marriage, before the father is fully acknowledged, the child's nationality cannot be fully verified. As such, according to the civil law and the family registration law, the mother should file the birth registration in her national country first, and then the father should acknowledge the birth of the child, and only then can the child be recorded on the family relations register and given a registration number. However, if the foreign mother is not in a situation to file the birth of the child in her native country, it can become an issue or a problem, as in this case. However, the Supreme Court ruled that in situations where the mother cannot file the birth of the child in her native country, that phase can be abbreviated and the father could obtain approval from the family court according to the so-called Sarang Act and prove the birth of the child through a DNA test or through another measure to be able to register the birth of the child. However, in this case, if the father obtained the DNA test results and the approval from the family court, it is possible to register the child, but it would be better if the mother could just be able to register the birth of this child in the first place to make things easier for everyone. You cannot but think whether this is possible, right? But unfortunately, according to the current Korean law, a foreign mother cannot file a birth registration of her child in this situation because the Family Relation Act only covers Korean nationals. The Article 1 of Korea's Family Relation Registration Act reads that the purpose of this act to prescribe matters concerning the registration of family relations of its people. So let's look at the background of how this act came to be legislated, because this is quite interesting. This article did not exist when we had the previous Family Relation Act, but at the 17th National Assembly, there was a full amendment of the act, and this clause was inserted on that occasion. When we converted the previous Family Relation Act to the current Family Relation Act, one of the main issues was to give the authority of controlling this matter to whom? Because previously the Supreme Court had long been controlling or overseeing this matter, but then the authority was converted to the Ministry of Justice because many people wanted the Ministry of Justice to carry this authority, but there had to be a legal basis to convert this authority to the MOJ, and that legal basis was to have the family register serve as a national register also, because the family relation register was only accessible to Korean nationals or those with a Korean nationality, which means that a civil registry would basically be the same as a national registry or a register of nationality. That is why the Ministry of Justice was given this authority to handle family relation related services as well. That was the argument of the government. However, this argument was not accepted at the end of the day because there was no need to highlight that element of nationality, and to give them that legal basis was under the sole and only purpose of converting that authority to the Ministry of Justice, in which case there could be issues triggered because the Ministry of Justice is an investigative authority. As such, we decided not to transfer that authority to the Ministry of Justice, but to leave it with the Supreme Court. That was the key discussion that took place at the 17th National Assembly. And that is why we decided to name the law the Act on Family Relations and not the Act on Nationality and Family Relations. But that article number 1 still remains as a remnant of that discussion that took place at the 17th National Assembly. So I just gave you some historical context, but regardless of that context, Article 1 still states that the law is only applicable to Korean people, which means that the family relation register is also only accessible to Korean people. So when a foreigner tries to report a birth, that birth report is accepted, but the child is not recorded into the family register. Even if that child was registered and lived for a long time in Korea for 10 or 25 years, but then it is later found out that actually that child was not a Korean and did not have a Korean nationality, the child's family register and resident registration number are immediately expired. In such case, the people concerned could be very confused and baffled, but the Korean government always gives the same excuse. They have to go back to their native country and file their birth registration there, and then come to Korea, and only then can they enjoy a standard status as a foreigner residing in Korea. But as I mentioned earlier, it is not always the case that a foreigner is able to file birth registration at their native country. There are cases where it's realistically or legally impossible for them to do that, in which case it could be very unfair to block access for foreigners to use the family register in Korea. And the most serious case could involve refugees. This is a case that actually happened. There was a Chinese person who obtained a refugee status in Korea. This took place in a time where China prohibited households from having 2 or more children. So this person could not file the birth of the second and third child, or else they would be invisible in China. So this person did not consent to that. They came to Korea and filed for a refugee status. The Korean administration saw that the person had a point and gave that person a refugee status. But after that person became a refugee, this person tried to file the birth registration for the children, but then the government said that since you are a refugee and not a Korean, you cannot register the birth of your children. And then the family was very confused because that defeats the purpose of their children being obtained a refugee status, because they are going to be invisible anyways. In order to resolve this problem, there is a need for us to pursue change. If foreigners are not allowed access to the family registration service and are forced to go back to their native country, their right to leave a country could be significantly infringed upon. Because in some cases, some countries require these people to physically come back to the nation to file birth registration rather than just filing it in the local embassy. But if a mother has to return to her native country, that person has to leave their children in Korea and return alone to her native country, which is a very difficult thing to do. But if you try to bring your child with you to your native country, that child has to have a passport. But in order to have a passport, the birth has to be registered. But in order to file the birth registration, you have to go back to the native country. Since the child does not have a passport, you have no option but to leave the child in Korea and go back to your native country. So this is a very unfortunate case where the right to leave or the child's right not to be separated from his or her parent is violated, which means that the parent ends up living in Korea, not being able to return to their native country because they don't want to be separated from their child. In order to address this situation, many international norms are stipulating that children have the right to be immediately registered at birth in the country of their birth. There are renowned international norms. I will not go over them again. But as I explained, Korea is not following the guidelines of these international norms, so the UN in 2012 and 2019 made two recommendations that it is concerned that Korea's birth registration system is not applied universally and that it has to make sure that all childs are entitled to the right to be registered at their birth regardless of the nationality or the residential status of their parents. It has made two recommendations regarding that note, and in 2018, the UN Committee on Elimination of Discrimination Against Women also made a recommendation saying that it could be unfair to force the foreigners to register the birth of their child at the local embassy, because this could trigger unfairness. And even if the child is born out of wedlock, they should be guaranteed the right to be registered at birth. In most countries, they are aligned with the international norms, unlike Korea. And if you have all the foreigners access such birth registration services, this could also be connected to the issue of obtaining nationality. So many people believe that we should approach this matter discreetly, but the countries that are applying the territorial principle are, of course, allowing all foreigners to access the services. But not only those countries, but also the countries that are applying the personal principle are mainly allowing foreigners to use this, to have access to the birth registration system as well. So worldwide, there are only few countries, exceptional cases, that do not allow foreigners to access the birth registration system. And so there is Japan of a case of applying the personal rule generally, but only the territorial rule as an exception for the birth registration. And they have a reason for that, because, and this has to do with the history of Japan's colonial rule. Since Japan had Korea and Taiwan under their colonial rule, they gave a Japanese nationality to the people of Korea and Taiwan, so to give them both the rights and the responsibilities that are same as that of Japanese people. So the Japanese authorities wanted to give them a Japanese nationality, but treat them differently due to the family register, which means that Japanese people with a Japanese nationality could serve in the military and also become a public official, but Japanese with a Korean or a Taiwanese nationality should not be entitled to the same right and responsibilities as that of Japanese people. This was a traditional practice that existed from the times of Japanese colonial rule, and this continued until the end of the Second World War, at which point the Japanese authorities took the Japanese nationality away from all Koreans and Taiwanese people. So you need to know some historic context of such practice, this was translated into the old Family Relation Act of Korea and also continued into the current Family Relation Act, which has inevitably made the system and the law only applicable to foreigners. So I think we need to think about whether if we really have to keep following this act when there is such a long-standing history to this. Even Japan, who started this trend, felt that there was a problem with it and decided to give full access to all foreigners regarding the birth registration system. Of course, unlike Korea, Japan's family register system is slightly different. Their register is built around the surname. So if it is impossible for a person who does not have a Japanese surname to use the system, so foreigners cannot make a family register, but when they are born in Japan, they can report the birth of a child and have a birth certificate issued. That birth certificate will function as a public certificate and be used to verify everything regarding a status of a foreigner. But Korea is one of the few countries that is still trapped in this issue of not allowing foreigners to register the birth of a child. So I believe that going forward, we will also be able to apply the territorial rule regarding this system as well. I'll just skip the other details since Mr. Ma has already explained it. And the key question here is how are we exactly going to adopt the universal birth registration system? The UN Convention on the Rights of the Child has made a clear recommendation regarding this. The child's status and its details regarding the birth has to be permanently recorded in a civil register. By permanently and continuously being recorded means that the child should not only have access to the birth registration system, but also their marriage, their death, and all landmark events that takes place across the course of their life should be recorded, and that the child should also be entitled to all public certificates that Koreans can issue as well. If we can build such a system, basically a universal birth registration system in Korea would mean a expansion of the family relation system to include foreigners as well. Just to conclude, as I mentioned earlier, the government is acknowledging that a universal birth registration system or birth notification system is important in protecting the human rights of children. It is therefore trying to prepare policies to this end, but many of these policies are targeting Korean children and not foreign children. But as a matter of fact, what the international conventions and norms are requiring is to give the exact same rights to foreign children as well. And we have to comply with these international norms to be able to truly say that we have built a universal birth registration system. So I would like to highlight the fact that the government's policy should not only include domestic children within the coverage. In that case, the law would only be half effective. We should also bring foreign children into the scope as well, and I would like to ask for your continued attention and interest toward this issue. Thank you. Thank you so much, Professor Hyun, for your insightful speech. Attorney Hyun has pointed out the restrictions of the current legal framework, which is only allowing Korean children to be registered at birth. And she also underscored the need to introduce a universal birth registration system for foreign children as well. And she also introduced some case examples where there are concerns over whether allowing foreign children's birth registration be connected with the issue of nationality, but as a matter of fact, she said that the countries who are applying a personal rule is also applying the territorial rule as an exception for birth registration specifically. Thank you so much again, Professor Hyun, for your excellent speech. We will now move on to the third presentation, which will be delivered remotely from our Belgian speaker, Ms. Liana Keith, from Platform for International Cooperation on Undocumented Migrants. Ms. Keith is working as a Senior Advocacy Officer on Labor Rights and Labor Migration. So, Ms. Keith, hello.
Hi. I can't see any of you, but it's a pleasure to be with you in any case. So just a few words to introduce PICA maybe before I go into the presentation. We're a network of 167 actually organizations that are working with migrants regardless of their status, based in 35 different countries, and most of those are in Europe, but not only. So we're based in Belgium, in Brussels, but we're really this regional and a bit larger than the European region network of organizations, and we focus specifically on the rights of undocumented people, but our members are very diverse and they work with migrants in various precarious statuses. So I will echo actually quite a lot of what's been said by the other speakers, but I hope in a complementary perspective of the situation in Europe and some practices that we see there. So I will share my screen with you. I think you should see that. So, as the other speakers have said, and we know, we always start from a human rights basis. So here I would just mention in the sense that human rights legislation is very clear that it applies regardless of the status related to immigration and resident status. So everything in the Convention on the Rights of the Child has to be applied without any discrimination for undocumented children and children of undocumented parents, including birth registration. And as the others have highlighted, birth registration is this right in itself, but it's very closely linked to other rights of the child: legal identity, nationality, protection from the state. With a birth certificate as well as evidence, it can be a key gateway to actually have access to age-appropriate support, to protection, as well as social services, including education and healthcare. One other element is also what we try to highlight in terms of having a kind of more comprehensive population register, is how crucial it is for public governance, to make sure that at a city level, at a regional level, at a national level, you actually have a clearer idea of who the population are and you can deliver services accordingly. And a point that I'll pick up on a bit later is also how it can contribute to preventing statelessness, particularly looking at the case of undocumented children. So in the European Union, despite it being such a crucial thing, there's no explicit right often in most countries for undocumented children to access birth registration. The reference is normally, as it is in also other areas like education, often to all children. But when that can be understood to include undocumented children, that leads to a whole host of practical barriers. And some of those include a possible duty to denounce if the parent is irregular, and irregular entry or stay is actually criminalized, which is the case in some European countries. There might be that duty, and I understand also there. Other practical barriers, administrative requirements, a lack of awareness, even if undocumented children do have the right, the person in the civil registry office might not know that. They might denounce them, they might turn them away. So there's fear and risk of detection. There's also discretion where, as I said, they might be turned away either because the person doesn't know better or because they have their own political positions. Costs associated with actually going directly, as well as indirect costs, like if you have to take a day off work and you're in a very precarious work situation where you just can't do that. And also because undocumented people often have limited access to healthcare services, if maternity services are also, if there's like a notification of birth via the hospital, then that's also impacted. And also, as described by the other speakers, the barriers to also register similarly with the embassies of the country of origin. At the same time, there we're really talking about children who are born in the country, but there is also low rates of birth registration in some countries of origin, or so meaning that children might also migrate with only an identity document where they're on their parents, they don't have their own document, and that might no longer be valid. So all of these contribute to them not really having their own identity documents. And I wanted to give, I think the others already gave a lot of different cases, but I wanted to also just share one that really struck me, as we also, our members work a lot with domestic workers, and it just shows again what this kind of administrative requirements, what it can actually mean for people in practice. And so this, this particular case is of a girl called Hannah, and her mother is a domestic worker from the Philippines, and she was working in Germany. She was supporting her husband and 2 children back in the Philippines, and she was raped by her employer, and as a result became pregnant. Because she became pregnant, she lost her employment and became undocumented. So Hannah was also born undocumented. Because Maria's residence in Germany was considered irregular. So with the help of one of our member organizations in Cologne, they helped her to get a tolerated status as a victim of rape in Germany. They helped her get a birth certificate for Hannah. But there's still been no recognition of paternity by the abusive employer. And because she's actually married as well, and had her husband in the Philippines, without a test to prove that he wasn't the father, Maria didn't have the right to put Hannah's name on the birth certificate. So she has a certificate, but no legally recognized name in Germany. So this is just a picture that she drew when she was 5 of the family that she wanted to have. And it's just another very stark example of what this actually means in practice for individuals. So in addition to the reasons why it was important for access to services and etc., as we described, one of the points I wanted to talk about a bit more is statelessness and barriers to nationality. So specifically for undocumented people, the kind of confluence of having discrimination in birth registration and discrimination in nationality laws puts them at particular risks of statelessness. And that's because there's no just pure birthright citizenship in Europe, in the European Union. And a lot of countries do require that the parent is regularly residing. And 14 European countries actually require regular residence either of the parent or the child, even for statelessness recognition. So undocumented children are being systematically discriminated against in these procedures. At the same time, they might not be able to get the nationality of their parents, as described by others, also if they're not able to register, but also because there might be additional requirements around actually getting the jus sanguinis nationality through their parents. And then in addition to that, irregular residence is often discounted or undercounted in naturalization, so that can follow a child through their whole life, where they're not really given any opportunities or have to wait a very, very long time to accrue enough residence to actually naturalize as a citizen. So our recommendations, how do we address this? One, the explicit right to birth registration, regardless of the status of the child or the parent, and including in that a prohibition of refusal. Also, minimal administrative requirements. And in this, we say, I mean, as it was also described by the others in terms of not requiring the ID documents and the marriage certificates if it's not possible to produce those, accepting certification, registration by mothers or fathers independently. But one interesting example also from many municipalities in Italy is to accept declared data and testimonies when in the case somebody is not able to provide that documentation, because it's really seen as a right of the child that shouldn't be inhibited through these administrative and these documentary requirements. Another key element is ensuring that there's no risk of immigration enforcement through that engagement, that the undocumented parent can really trust that they can engage in that procedure. So that needs to be enshrined in law and policy and in practice, for example, through guidelines and training, that there should be no data sharing between the civil registration and immigration enforcement. This may also require, and we in any case fully advocate for decriminalization of irregular entry and stay, because of this duty to denounce that I mentioned, and I think you're also familiar with there. Another way to also do this is through granting a residence permit. For example, in Italy, there was actually a discriminatory measure introduced where a residence permit would have to be shown during birth registration. And then through a lot of different advocacy efforts, it was they were able to change that and actually introduce the possibility for pregnant women to get a residence permit for the duration of their pregnancy and 6 months of their child's infants, and also for the father. So that was one way also that they could provide a bit more stability and ensure that the residence permit requirement, which in itself is discriminatory, was kind of circumvented to make sure that that would be protected. And then another aspect of this, and it's certainly not in any way a either or, but to also allow registration by a third party, for example, the doctor that delivered the baby, to if really the parent feels unable to come forward, to give that other option. So those are some of the recommendations that we have, and some examples briefly of where we actually see them in practice. Complementary things that also need to be creating the framework for a universal birth registration to really include undocumented children would also be non-discriminatory access to health services, including maternity, the non-discriminatory access to nationality regarding irregular residence of the parents and child, and also other mechanisms for children and young people to actually regularize their status and access their kind of full inclusion in the local communities. Thanks very much, and I'll stay with you for the discussion if there's any further questions.
Thank you very much, Liana Keith, for your excellent presentation. It's around 3 a.m. in Belgium, so thank you very much for joining us at such an early hour, and thank you for giving us excellent presentation. It is of a great help. Liana Keith talked about how the birth registration is a right of a child, but it is also closely related to other rights of the children, highlighting the importance of birth registration rights of a child. It may be a bit confusing for you, but the undocumented child is, for instance, in Europe, is undocumented immigrant children who are residing in Europe without any permit to stay. And she argued that the permit to stay should be given to all these children, with some detailed examples in the EU countries. Despite it being such a early morning or late night, Liana Keith will be with us during the whole discussion. So if you can upload some questions that you have, it will be helpful for our discussion. We will now begin the panel discussion. We had 3 presenters, and the panelists will join the discussion as well. For each discussant, I'll give you 10 to 15 minutes on birth registration system. First, Deputy Director Lee Jin-young from the Ministry of Justice, please.
Yes, hello, my name is Lee Jin-young. I'm from the MOJ, Human Rights of Women and Children Division. First of all, on behalf of the MOJ and all other Korean government ministries, I would like to mention that yes, it is true that we have been receiving many recommendations from the UN committees, and we do understand the necessity of a universal birth registration system for all children. And also, we do believe this is a matter that should be immediately addressed, since there is no way for a undocumented child to have his or her birth registered. We are indeed seeking for a solution to address this matter, and I think there will be many questions regarding the birth notification system concerning medical centers, so I'll just touch on that. In May, there was a proposal made by the Legislative Improvement Committee to introduce a birth notification system. This was done by a team that is not exactly related to the department that I'm working in, so I do not know about the details, but I think that the proposal is currently under review. This system is to allow all children to be subject to the birth notification system, or notification of birth at medical institutions. And if it is implemented, medical centers would be obligated to inform or notify the birth of every child, including undocumented migrant children. We will also be seeking ways to incorporate this into the overall birth registration system. And also, many speakers have mentioned that we have to improve the Family Relation Act. The MOJ is trying to look for the most appropriate way to implement these institutional enhancements. As the professor mentioned earlier, I do agree with the fact that we have to amend the Family Relations Act to make sure that there's no discrimination against undocumented migrant children. But yes, you gave some historical context to the current law and why it is the case that that has came about, and it was not indeed the original purpose of the law. But there is not a separate nationality register currently kept in Korea, and the civil registry is practically serving as a nationality register at the current stage. And the ultimate goal of introducing a universal birth registration system is to allow all undocumented migrant children to enjoy their human rights. But in order to incorporate them into the family relation register, there are further matters to be discussed. And we should also discuss the matter of merging or not merging the foreign registry with the civil registry while trying to address this matter. So we're trying to look into many overseas cases regarding this issue, and I do believe that there was a presentation on a special type report. We're also trying to consider the possibility of that as well. That's all for me. Yes, Deputy Director Lee, thank you for your comment. You mentioned briefly about the birth notification system concerning medical institutions currently being reviewed by the MOJ, and you said that basically, practically, the family relation register is serving as a nationality register, and I think the undocumented migrant children that you were just talking about means is somewhat like the undocumented children in Europe, and you said that you will try and do your best, and the Ministry of Justice will also be committed to expanding the coverage of the law to include all marginalized children as well and to build a more inclusive society. Thank you for that, and we will now listen to the comments from Mr. Hong Joo-hyun, Deputy Director from the National Court Administration.
Good morning, good afternoon, and good evening. I'm working at the Family Relations Division at the National Court Administration. The laws, the regulations, and the system in relation to the family relations are covered by our division. 3 years ago, I was working as the person in charge of the family relations at the administration. The two presenters introduced about the Korean Supreme Court ruling in 2020. I'd like to tell you my personal opinion on that and its impact on our actual work at the administration. Regarding this ruling, the media actually reported it. It was covered as a major news. As a person in charge of the practical matters, I'd like to tell you about how this will be put into practice. The title of this news was the case for the biological father's birth registration. Unmarried father. When the unmarried father does not know the identities and detailed information about the biological mother, the unmarried father is allowed for the birth registration. This is under the provision of the Family Relations Act of the Article 57. And for this case, this was actually rejected at the appeal court, but this was accepted at the Supreme Court. The child involved in this case was born in September 2018. I was born in a hospital in Korea. The biological mother of the child is a Chinese. Because of the fact that the mother's passport cannot be renewed at the embassy, she had to get the travel documents and then entered Korea based on the travel documents. The applicant of the birth registration, who is a biological father, was a Chinese and acquired Korean nationality in 2013. And the applicant and the biological mother was not legally married, but de facto married. In 2018, they gave birth to this child. And regarding this ruling, the first thing that I'd like to mention is about the nationality of the child. What is the nationality of this child? According to Nationality Act of Korea, at the time of the birth, if both parents are Korean at the time of birth, then the child is a Korean national. But the father here is a legal father, so if it's extramarital child without any legal marriage status, legally speaking, this child is a foreign national. But the details of this ruling and the media report that this is the first ruling that recognized the right of a birth registration for a child that is born in Korea. But the problem and the characteristic of this ruling is that the child is actually a foreign child. Second thing we have to look at is that the birth registration was actually impossible in this case. If you see the current Act on Registration of Family Relations, the biological father could actually file the birth registration. According to Article 57 and paragraph 1, the biological father could make a birth registration, but the problem in this case was that to make a birth registration, you have to provide two documents. Number one is a birth certificate, which is issued by the hospital. And the second is the certificate of a marriage of the biological mother to decide whether the biological mother is in marriage or who is the spouse. And there was a birth certificate issued by the hospital for this child. Secondly, the certificate of the marriage status was not provided because she's renewal of the passport rejected in China, so it was very difficult for her to obtain the certificate for marriage status. In this case, was the birth registration possible? In conclusion, yes, it was possible. If the certificate for marriage status cannot be provided, she could get any public certificate or any public guarantee to replace the certificate of marriage status to make a birth registration. In this ruling, this case was actually possible to file a birth registration, and I don't know exactly what led to this Supreme Court ruling, but legally speaking, for this case, birth registration was possible. But due to this ruling, and according to under the Article 57 and paragraph 2, the scope of the application of the law was expanded. That is meaningful. The birth registration was possible, as I mentioned, according to Article 57 and paragraph 1. But if the birth registration is made according to Article 57 and paragraph 2, is it any faster for registration, or is it any cheaper in terms of the cost? If you see the paragraph 1, which is the existing provision on birth registration, the biological father should provide a birth certificate or the guaranteed certificate to go to the city office or district office to make a birth registration. And the register is not made immediately, and they would give out the certificate of the report, and then the biological father should file to the Ministry of Justice for the certificate. So the Ministry of Justice actually files the registration to the country of origin. For the Minister of Justice, would take a few days to notify the result to the district head. So that takes about a few days. But if you follow the procedures under the paragraph 2 of Article 57. As soon as the birth is made, the father goes to the DNA testing and pay a few $100 and to receive the certificate of the paternity, and then goes to the court of the family court for the confirmation. It takes a few months, maybe 1 month if it's short, and then the confirmation is notified to the biological father after a few months. And then the father goes to the district office to make a registration. So a few $100 for the DNA testing. Also, it takes a few months for the court to confirm the paternity relations. So that's the realistic comparison between the two cases. Another important thing is that in the end, how is the register of the child and the documentation of the child differ? According to the paragraph 1, which is existing law, when the Minister of Justice sent the notification, the child will be documented as a Korean in the register, and the biological father and the child will be connected in the register. So the biological father will be now registered in Korean register, and the mother's information will be documented in the register as well. But if you follow the paragraph 2 procedure, then how the register would differ from the paragraph 1. because this is the first ruling and there is no precedent we have, so this is just my presumption. The Supreme Court ruling has been confirmed, and after that, the Supreme Court actually issued the same reason for the case. The biological father probably went to the district office to make a birth registration based on this ruling. Was the civil servant at the district office able to handle this registration report? I believe that there are two cases probably. First off, in the certificate, if you read the reasons in the ruling, it is very evident that the mother is a foreigner, and it's evident the child is not a Korean national. If you have to ignore the paragraph 1, then you can probably include the child in the register and then make registration. If not, because the foreigner is not allowed to be registered on the family relations register, so the child can be registered as the child of the father who was registered in the registry, and the registry is not documenting for the child. I don't know out of these two options which option was chosen, but what's clear is that if the district office is to create a registry for the child, then the Article 53 and the paragraph 1 of the Registration Act of Family Relations would be ignored. So that would be a huge burden for the public servant. At the ruling, it uses a phrase of a right to be registered for birth. We have a birth registration and the registration of family relations, but the right to be registered for birth, this phrase, it can be interpreted as the right to birth registration, or broadly speaking, this could be seen as the right for birth registration plus documented in the registry of family relations. So in a smaller scale, this is meaningful as it has expanded the definition of registration, or whether it has also expanded interpretation of registration of family relations. I believe it's debatable. If we interpret in a broader sense, we have to ignore Article 1 of the Act on Registration of Family Relations, because we are documenting foreigner in the Register of Family Relations. So in terms of the birth registration, I believe this is an issue that requires a further debate and discussion in the future. Lastly, based on this ruling, it interprets paragraph 2 of Article 57 as an example. It also defines the applications. Lawmaker Kim Mi-hee reflected this ruling in the new legislation bill. The most important phrase here is that when the documents necessary for birth registration is not provided for or prepared, but this ruling refers to the mother's marriage status certificate as the document necessary for the birth registration. But the most important document for birth registration is birth certificate. If the biological mother, for the personal reason or without any justifiable reason, cannot obtain birth certificate, according to the paragraph 2 of Article 57, should we allow the birth registration? In some sense, the biological mother did not provide the birth certificate or overlooked the birth registration. Maybe we can resolve this case based on this ruling. But negatively speaking, this could be a serious issue, because the birth registration can be filed without birth certificate, we would not even know if the child was actually born, and we will still allow the birth registration. This is a serious issue. So by the amendment of the Act on the recognition, registration of family relations, in the past we allowed the guarantor to guarantee the birth of a child. Now this is impossible. This act has been amended to prevent any false report or registration of birth. If birth certificate is included as a document necessary for the birth registration, then we may have any additional issues that we had. So this ruling was discussed in depth by the two presenters. So I explained about this provision in detail. Thank you very much. Thank you, Deputy Director Hong Ji-yeon, for the good discussion. At the Family Relation Division of the court, they had their own issues in dealing with the issues, so he explained about that. The presenters talked about the 2020 Supreme Court ruling, so he explained about the case in details. What was interesting is that if the child could have been registered easily based on the paragraph 1 of Article 57 instead of paragraph 2. So in some sense, depending on the legal, application of different laws, the registration could have been made more easily, but it had to go all the way to the Supreme Court for the birth registration. During the whole time, the child could not be registered, and the child was actually the victim of all of this issue. The Supreme Court ruling, whether it is regarding the registration rights or the birth report right, he mentioned about that as well. So the birth registration right is not just the right for the report, but the right for registration as well. So this is an issue that we can discuss about more in depth. Next discussant is a research fellow, Song Hyo-jin from Korea Women's Development Institute.
Yes, hello. I'm from the Korean Women's Development Institute. My name is Song Hyo-jin. I would just briefly like to add 3 things to what the other panelists and speakers mentioned. First of all, the recommendations made by the committees are very encouraging and gives a lot of promise, but following that, as a matter of fact, there has not been any practical progress on, or I have not heard about any progress that has been made regarding the proposal for the birth notification system. From what I gather, just briefly, I've heard that the Family Relation Act is under the scope of MOJ, but the related administrative services is controlled by the family relation authorities, and there's also that element controlled by the Ministry of Health and Welfare that has to do with the hospitals. So since there are many stakeholders involved, there is a lot of confluence of the roles and responsibilities, and I understand that of course this is very difficult and complicated, but I think, well, yes, you've said that you would be reviewing this and consulting this, but some time has passed since then, and still I'm not hearing about any progress related to the actual legislation, so I'm looking forward to that. And another thing is that our speakers have discussed in much detail about the family relation and birth registration of undocumented children. I do completely agree with all of you on the fact that they are marginalized and outside of the legal framework. Well, if we are to introduce the birth notification system, the medical institution should not be responsible of verifying the nationality of the children. Well, then how should the government verify their nationality and register the birth of the child? I think this is a matter that we have to consider as we pursue the legislation of this. And Article number 1 of the Family Relation Act is being brought up consistently today. This is something that we come across very frequently since we understand that many foreign and undocumented children are outside of the legal framework and in the blind spot of the act. I made a proposal to delete the word the people from article number 1 to make room for interpretation and not to make sure that the interpretation of the law is not conducted in a overly narrow manner. And something that occurred to me today was that maybe we could rephrase the law to include its people and the people who were born in its territory. Or another option is to include paragraph 2 to the Article 1 to include an exception to allow people who were born in Korea to be entitled to the same rights, in which case we would be address the problems that have been mentioned today even partially. So if we could make such a legal basis, that could go a long way in expanding the legal coverage to include all of the people who were previously marginalized. So this is something that we could discuss in the years to come. And another topic that is being mentioned is the problem of a single mother and single father. There have been many improvements, and the policies have been constantly improved to expand child welfare services and healthcare services. The government has been announcing many related measures recently, but this is not enough. On top of this, even if we introduce the birth notification system, another challenge that still remains is to, at the end of the day, in order to report the birth of the child, you may have to inevitably obtain the approval of a family court. In this case, the birth registration would be inevitably delayed, and costs will be incurred, and the administrative process would be very lengthy, which could cause some difficulties for the applicants. If we look into this problem in more detail, you end up asking the question, why does it have to be so hard to simply register the birth of a child? Do you really have to obtain confirmation from a family court? So much so to risk the delay of the birth registration. If the birth registration is pushed back and postponed over the course of that time, the child would end up suffering and experiencing disadvantages. So under the current law, there are cases where you have to report the birth of the child through the approval of the family court when the child is born at home, for instance, or in other exceptional cases, some less frequent cases. In this case, you have to obtain confirmation from the family court. But as I mentioned, the procedure itself is very complicated, and the vulnerable people do not have simply the time or the time to go through such complicated administrative process because they don't know much about the process. They have little understanding, and as I said, there are costs involved, and the government does not support those expenses fully. Even if they receive legal support, it's going to take significant time and expenses and effort for them to go through all of those procedures just to register the birth of their child. So we have to take these difficulties into account. If we to force them to go through these procedures by law is to build institutional barriers hampering people from trying to register the birth of their own children. So I think in pursuing institutional improvements, we have to, of course, take into consideration all of those things that have been mentioned today. And on top of that, there's also the matter of obtaining confirmation from the family court. And also, there's the issue of verifying the father or the mother. If we require the applicant to verify the nationality of the father and the mother first before registering the child, this could also lead to some delays. So what if we allow them to first file the birth registration application of the child even when the nationality of the parents are under review? I do understand that there are, of course, exceptional cases when the family court's approval have to be obtained, but in other cases where it's not so necessary, we have to try and introduce measures to add some flexibility and try and process the birth registration applications as soon as possible. And nobody runs to the court first when they try to register the birth of the child. They try and go to the administrative office first, and then they find out that they cannot register the birth of the child here and have to go through the court instead. So what I'm saying is we have to try and help them save all the effort and the time and the money by expanding the scope of the law, and we also have to take all of these case examples into consideration. And just to conclude, medical institutions notifying the birth of the child or the birth notification system has to be adopted as soon as possible. But in the meantime, we should amend the Family Relation Act so that non-Korean children can also be registered immediately at birth. And furthermore, there are children who are born out of the hospitals. And in this case, we have to expand the institutional and legal frameworks so that all of them would be entitled to the same human rights. Yes, Ms. Sung, thank you so much for your enthusiastic comments. I think many people are interested in the intergovernmental discussions, pan-governmental discussions, and the progress that have been made so far. You said, does registering the birth of the child have to be so difficult? And you have also mentioned some cases where we have to expedite the birth registration of a child by allowing them not to obtain confirmation from the family court. And you also highlighted the fact that foreign children also have to be registered at their birth. And in order to do that, we have to, of course, introduce the birth notification system and amend the Family Relations Act. The last panelist for this session is Mr. Park Byung-soo from the Child Rights Division of the National Human Rights Commission.
Hello, I am Director Park Byung-soo of the Child Rights Division from National Human Rights Commission of Korea. This is such an important theme, the universal birth registration. And I'd like to thank the staff of the Seoul Human Rights Conference, all the presenters and discussants for joining all together and inviting me as well. Regarding the universal birth registration, all the presenters gave some good insights. And rather than focusing on that, in 2017, the National Human Rights Commission of Korea made a recommendation for the improvement of birth registration for the universal rights. So I'd like to talk about the implications and its meanings. At that time, the National Human Rights Commission targeting the doctors, the medical staff who are involved in the birth or delivery of a child, we wanted to recommended the government and the court to revise the law so that those medical staff are obliged to make a report for the birth. And this bill was at the National Assembly, and we expressed opinion that this law should be passed as soon as possible. As you may know, our commission deals with the policy system, the law and practices. If it is necessary, the improvements are necessary for the improvement of rights for the people. Our recommendation, when we make recommendation, the relevant governmental body or the organization should notify our commission within 3 months whether they will accept our recommendation. After our recommendation, the Korean government agreed with the direction and the intention of the recommendation, but the government said there should be a further discussion with the government organizations according to their reply to us. At the time, the background of our recommendation is that in 2015, our commission conducted on-site monitoring for children. In 2015, during the monitoring process, we found some victims who are children whose birth were not registered. In March 2017, we found the children who are not registered for birth by the children, and for 18 years, the child could not receive any education or protection by the state or any medical services as well. So, based on all of these cases, the National Human Rights Commission of Korea considered ways to improve the birth registration system. At the time, looking at these cases, the Commission identified the type of disadvantages the child would receive when the birth registration was not made. At the time, we concluded that the birth registration, and if the birth registration is not made itself, is a physical abandonment, and the child who are not registered can be exposed to if the child is exposed to any disease or any risk, then there could be any medical, the child can be medically neglected, and there could be educational neglect because the child may not receive education because of the non-birth registration. If the child is not registered for birth, the child can be exposed to the abuse by any people around them, and the country cannot recognize that abuse at all, so there is no measures against that. As the recommendation by our commission, the medical institutes are required to report the birth. According to our recommendation, there were some concerns about that. If the parents do not want the medical institute to report for the personal reasons, if that's the case, then they may go to some illegal medical institutions. At the time, despite all of these concerns, conclude that we should come up with other measures to protect the privacy, and this is something the government is considering now as well. So we can come up with different measures to protect the privacy of parents or pregnancy or for birth. There can be any additional support measures, so there should be a comprehensive measures. And because of the privacy issue, we cannot concern too much about the privacy infringement by the report by the medical institutions. Also, there was concern that the medical institution will be burdened with too much duties and too much cost imposed on them. But the medical staff and the doctors are included in the list of people who are obliged for the birth registration according to our Family Relations Act. And the notification by medical staff itself is not actually a huge burden for their work or cost. So that was our conclusion at the time. Recently, as many people have seen, and it was told by lawyer Ma Han-eul, in a fridge of a household, there was a dead body of a baby found that was stored in the fridge for a long time. In 2017, when the birth registration system was not established, there was a risk of the child abuse, and the state could not protect the child. I believe that all of these concerns actually have been materialized in this case. In 2017, there are many concerns of the side effects of the birth registration system. There was a lot of discussion on that as well, but still the social consensus is insufficient on this issue. And due to that lack of social consensus, the universal birth registration system cannot be fully established or materialized. As a person involved in the Human Rights Commission, I feel very burdened, and I feel a huge sense of responsibility. As the lawyer Mahano mentioned in his presentation, children without the birth registration, of course, it is an unfortunate situation, but going beyond that, for improvement of the child's rights, we have to have a sense of responsibility, and I strongly agree with that. The child whose birth is not registered can be not registered in the public ledger, and because of the lack of protection by the state or by my parents, and the child can fall as a victim of the system, and we have to improve this situation. We talked about the universal birth registration system in this forum. It means that any child has a right to be registered in the state and be protected by the state. We should consider all of these rights, and we will reflect this in our work at the National Human Rights Commission. Thank you very much. Thank you, Director Park Byung-soo. In 2017, the National Human Rights Commission made a recommendation for the birth registration birth report by the medical institutions, so he elaborated on that recommendation. And he also mentioned that the state's responsibility and also the possible future direction of the National Human Rights Commission for universal birth registration. We have about 15 minutes left for this session. We have a lot of questions uploaded online. So let's have some Q&A session on those questions. First off, including the pre-uploaded questions, the first question is that the birth registration is child right. It is also right to the family who will live with a child. The local governments can do something about the birth registration improvement for child. What can the local government do for this? Well, we talked about the efforts by the city and the district office. So lawyer Mahano can answer to this. And we have Liana Keith. Maybe you can tell us about how the local governments in EU are making efforts for birth registration system. So lawyer Ma first, please. First off, according to the current law, the head of the local government can make a birth report. But realistically, the head of the local government has not made many birth report so far as I know, because it is difficult for the third party to step in and recognize the birth of a child without the parents notifying it. Also, the civil servants are not fully aware about this, and they're not prepared to make a quick response when such an incident happens. If the head of a local government has to find the birth registration, I believe that it will be a huge burden, probably. I think that's how they feel. The research fellow Song Yo-jin mentioned about the birth registration system. And before you try to file the registration, many people wouldn't know how complicated it is. Even the people who are working in the front line are not fully aware of it. For instance, I talked to many staff members who are in a child protection institutions. They actually talked to me a lot and discussed with me a lot about the birth registration procedure, because they would know well, and they find it very difficult and complicated in terms of the system. As you mentioned, if there is any birth registration filed, then any advice or support can be made to help them through the complicated process. And during the time when the birth registration is not made, we can provide any support to prevent any risk occurring for the child who are not registered yet. Thank you very much. Liana Keith, can we have your opinion on this?
Sure. I mean, both of the examples that I mentioned actually very briefly were quite municipal level, or they have a very strong role, let's say. In the Netherlands, as I said briefly, the law is explicit that undocumented children have the right to be registered. And the municipal level is actually responsible for that and prohibited from, there's good local level protocols in place to say that there should be no discrimination actually when an undocumented parent goes in. What remains there is some practical barriers, and what our partners there in the Netherlands have really been asking for is more training and guidance to make sure that those civil servants, as the previous speaker was saying, actually are aware of this regulation and how to actually implement it in practice, and then looking at what kind of documentary requirements would be actually put in place where there is some flexibility at local level. There's also practice of working with local groups. To be clear, when I mentioned also the involvement of third parties in registration, I didn't just mean the notification side, which involves the health professionals, but actually they're having it integrated into the registration procedure. And obviously a third party can't do that without notification from the parent, and there's safeguards that need to be in place to make sure that it's the child is being protected and the family is being protected. But these kind of measures, if working in cooperation with medical professionals and with local community groups, can be a real way of just bridging these gaps for certain marginalized communities. The example in Italy as well, it's really at municipal level where they've looked at what kind of documents they can accept, how to involve people to give testimonies where there isn't documents being required. And there you see very different practice in the different cities and regions. So there is a strong role we see, at least in Europe, for what can be done at city level. And I would just underline that we do very much address it in that perspective, that it's about integration and non-discrimination within that mainstream civil registration and really proactively addressing the barriers. And it is very possible. We do see that there is a large level of birth registration of undocumented children even in Europe, but what's lacking is these kind of proactive policy really to address some of these barriers that can be absolutely fundamental for a child's rights and inclusion in the long term.
네, 좋은 말씀 감사합니다.
Thank you very much for your good comment. Next question.
들어온 질문인데.
The next question goes to the National Court Administration. So, what is your thought on the universal birth registration system? You have given us such a detailed presentation, so perhaps you can be brief in your answer. Yes, regarding the universal birth registration system, there are many legal amendments being proposed, and the ministries are conducting joint consultations, and we are receiving requests for consultation from many external parties, so we are joining that also. From the perspective of National Court Administration, we're not opposing this matter or viewing it negatively. Our stance is to try and accept the proposal so as to make sure that every child is registered and entitled to those rights. Of course, we agree and understand that purpose and the spirit of that, but due to the nature of the judicial authority, we are quite passive toward operating the institution directly or legislating related laws directly. So, yes, thank you for your comment. And this is a question for government authorities. So perhaps, Ms. Lee, you can answer the question. If a child is born at home and there's no document to substantiate the birth, can the child be registered? Or can you amend the law to make sure that these children are registered? So, Ms. Lee, Deputy Director Lee, if you're ready. Yes. Currently, as was mentioned earlier, the remaining 0.5% of the children are born at home and not at medical centers. But of course, it's possible, right? They can be registered by local governments or prosecutors. There are ways to register those children. If there is a lack of policy or institution that do not allow the children to be registered, of course we're going to address those loopholes. Yes, that was a question on the lack of institutional protection. And there's, I think those are about all of the questions that we have collected. We have about 5 minutes left. So I would like to ask our presenters and speakers if they have some additional thoughts after listening to the comments of the panelists. So Mr. Ma, Ms. Hyun, and Liana, could you give like a 1-minute short comment?
Yes. Thank you very much for participating in the discussion, and thank you for your valuable opinions as well. The Deputy Director Lee Jin-young mentioned about the ministry's position to add, if you're pregnant and after the pregnancy until the birth, we have to make sure that the person is not isolated and that she's connected to the resource in the local governments and receive the welfare benefits, and the birth can be made within the welfare system of the region. So that was something that I wanted to add. Nobody should be isolated in giving birth to a child. And the research fellow, Song Hyo-jin, also made a very enthusiastic comment, and I was moved by it. The birth registration system is complicated, and we will conduct more research to make it easier for them, for people. As it was proposed, as of now, the current family relations system is based on the relevance system of the family member, and how can we include this how can we apply this to foreign nationals? This is a major issue. As it was mentioned, the birth registration by the single mother or single father, there are many issues that need to be supplemented, and that issue need to be confirmed by the court first. So I believe that it would be much better if the child can be registered first during the process. So maybe including some case-by-case system can be an option. And maybe selecting territory principle can be an option as well. Thank you very much.
Yes, since I don't have much time, I just want to mention one thing and one thing only. I just heard the Deputy Director from the National Court Administration say that if the Family Relation Act is amended in line with the verdict, that might give rise to an increase in cases of false reports, false birth registrations. But in my opinion, no law can be completely perfect. Always there are loopholes. And what we have to do is to try and minimize the risk of people being isolated and try to minimize the number of people that are marginalized as possible. I think the question that we should answer is, are we willing to leave people continuously isolated just to minimize the risk of false reports? A bigger problem is the infringement of human rights, and this has to do with the interests of the government. And we can try and address this risk of false reports through other measures like sanctions or fines. We could forfeit all the unlawful proceeds that people have collected through false birth reports. So there are many measures try to punish these people who try to take advantage of the law. A more important priority is to protect the human rights and the people who are marginalized, because there is no way of recovering all those discrimination and disadvantages that they have experienced. So I think a stronger focus should be placed on protecting the people rather than the risk of false birth reports. Thank you. And last but not least, Liana, whenever you're ready.
I would completely echo what you've just said, and maybe just to add on that, I think it's really important to consider the impact on children in early childhood development, how that has, it's not only a violation of their rights as at that time, but the long-term impacts that marginalization and deprivation have on children throughout their childhood and potentially as they grow into adulthood. So it really is crucial, the aspect around immediately after birth being really integrated into your considerations, and seeing how it can be really addressed as a right of the child from as soon as possible, to include them in a system that is about ensuring their access to protection from the state, to their legal identity, but also services, nationality, and everything that comes with it. And maybe just to part with saying I'm really hopeful, actually I'm grateful for having been invited to join in this session, and very hopeful, having heard the discussion and the interventions from all the different parties, that you're really moving towards a truly universal birth registration in Korea. So if there's anything more that we can provide from European perspectives, we'd be very happy to support and really find this an excellent initiative.
Thank you very much for joining us and giving us good comment despite it being an early morning in Europe. It's time to wrap up now. It was reported by the media that a child was found in a fridge, dead, without any birth registration. We talked about many concerns, and we discussed on why universal birth registration system cannot be established in Korea. But during all this discussion is going on, the children will be the victims. And I hope that Korea can establish the universal birth registration system as soon as possible, so that all children born in Korea can enjoy their rights to birth registration. This concludes the session 1. Thank you very much, all participants and discussants.
That marks the end of the first general session. I would like to thank the moderator, Kim Jini, and Mr. Va Han-hol, Hyun-so Hee, Lee Jin-yeon, Hong Ju-hyun, Song Hyo-jin, Park Byung-soo on site here with us. And also our special thanks goes to Ms. Liana Keith for joining us at such a late hour all the way from Belgium. So, ladies and gentlemen, we have now discussed the universal birth registration system and human rights in session number 1. The right of a child begins from the right to be registered at birth. So with that, I would like to conclude session number 1 of Seoul Human Rights Conference 2020. We will take a 1-hour break and resume at 1 o'clock with the second session. Likewise, you can be connected online, real time, with us here on site. So I'll see you again in an hour. Thank you.
여러분, 뭐 하고 계세요? 저랑 같이 서울시 인권 정책길로 산책하실래요? 서울시는 2012년 팀 단위가 아닌 과 단위의 인권 담당관을 신설하고 서울시 인권 기본조례를 제정한 것을 시작으로 전국 최초 시민 인권 보호관 제도 도입 운영. 인권위원회 구성 운영까지 시민의 인권 보호와 증진을 위해 제도적 기반 구축에 있어 선도적인 역할을 수행해오고 있어요. 과거에 있었던 잊어서는 안 되는 우리 인권 역사의 상징적인 공간들에 이렇게 도장을 꼭 찍어놓고 그 역사를 시민들과 함께 걸으며 기억하고 있죠. 그리고 현재 일어나선 안 되는 인권 침해를 예방하기 위해 철거 현장 인권 지킴이단이 시민들 곁을 지키고 있고요. 또 서울시 행정에서 인권 침해가 있었다고 판단되는 사건에 대해 시정 권고를 할 수 있는 시민 인권 침해 구제위원회가 인권 침해로 인해 고통받는 시민의 목소리에 늘 귀 기울이고 있습니다. 든든한 시민 인권 보호관이 언제나 기다리고 있습니다. 서울시는 국내 최초로 시민이 인권 침해 및 차별 사건에 대한 결정 과정에 직접 참여할 수 있는 시민 인권 배심원제를 도입하여 시민 스스로 인권을 지킬 수 있도록 돕고 있습니다. 서울시는 각 분야 인권 전문가들과 함께 앞으로도 시민의 인권을 위해 계속 걸어나가겠습니다. 서울시는 서울 인권 컨퍼런스를 통해 모든 시민의 인권이 바로 서는 행복한 사회를 꿈꾸며 인권 행정이 나아가는 방향을 모색합니다. 함께 누리고 포용하고 참여하는 인권특별시 서울.
Music always embraces an era. It holds the time, space, and scenery of the city that we love.
Seoul is a truly special city. This trail is an old railroad track that, instead of being torn down, was completely reformed. The city has created a sense of ease and romance I had forgotten, and it surprises me every time I experience it.
You see? What another perfect reason to stay.
I moved to Seoul and now live and work here. I was very impressed with this culture that maintains original aspects while adding a new sense.
It's because empathy is what matters. People-centered values that prioritize the happiness of everyone are found across Seoul, where past traditions and the present coexist.
That warm feeling. Isn't that a great reason to live in Seoul?
I think Seoul is filled with more energy than any other city. Such energy becomes the possibilities of the future. Various attempts to connect individuals and businesses create new business opportunities. And it makes Seoul a city where creative investments are possible with advanced 5G technologies.
And more passionate city.
Seoul, a special city for you and me. I saw you. A city filled with joy. A city dedicated to its people, where past traditions coexist with the present. A city filled with creative business opportunities. special city for you and me. I Seoul you.
여러분 안녕하십니까?
Ladies and gentlemen, welcome back to the 2020 Seoul Human Rights Conference. I'm the MC for today's conference, Park Sun-young. Hello again. Today we will be discussing the international human rights governance and the way forward for the global human rights policies, and the conference was held in this spirit. It is my honor to be able to welcome all of you, both offline and online, to discuss this very topic. This year marks the 5th year of the Seoul Human Rights Conference, and this year's theme is Human Rights in Crises and the Role of the Seoul Metropolitan Government. We have gathered both the experts from both Korea and online all over the world to discuss this topic in the general session and the special session, and the upcoming session would be the second general session. This year, due to the spread of COVID-19, for the safety of our participants, we are connected online and the conference is held remotely. I am very sad to not able to meet you in person, but I do believe that we are still together and connected online, so I would like all of you to bear with us until the very end of the conference. The studio, the on-site venue, has been disinfected this morning, and the conference is held in line with the government's preventive measures. In this session, and until the very end of the conference, myself and all of the speakers will be wearing a mask. So I would like to ask for all of your understanding, since this is for the safety of all of us, even if there are some inconveniences regarding the audio. So with that, I would like to officially begin the second session centered on the policies and human rights of multicultural single-parent families. This session will be centered on the policies and human rights of multicultural single-parent families, and we will be discussing ways to build a sustainable city and to transform Seoul into a sustainable city where nobody is marginalized or isolated, and every citizen has the right to raise their child in a stable manner, enjoying all of the rights that they are entitled to. This session will be moderated by the president of the Global Single Parent Center, Ms. Hwang Sun-young. President Hwang has been working at the Seoul Metropolitan Single Parent Family Support Center, and she's also an advisor in crafting single parent related policies. With that, I would like to give the floor to President Hwang. It's nice to meet you, ladies and gentlemen. My name is Hwang Sun-young. I'm the president of the Global Single Parent Center. At the center, we provide advice and proposals regarding the policies. We support households at risk, and we also support the human rights of many multicultural families. Today, we would like to discuss the way forward for multicultural single-parent families. And first, I would like to acknowledge the presence of our speakers today. First of all, we have the president of the Seoul Metropolitan Single Parent Family Support Center, Ms. Lee Young-ho. We also have from the Convergence Institute for Multicultural Studies at Inha University, Ms. Lee Chun-yang. And the panelists today are Director Jeon Young-sun from the Korean Hanbumo Association. We also have Research Fellow Kim Hee-sun from the Korean Women's Development Institute. We also have a member of the Operations Committee of the Global Single Parent Center, Ms. Ho Seol-hwa. And we also have here with us today Mr. Kang Sung-ho, team leader of the Multicultural Family Team of the Seoul Metropolitan Government. So today, Here we will be presenting proposals for the improvement of Seoul City's policies. And first of all, I would like to touch upon the background to which we are gathered here today. There are causes that trigger the infringement of human rights for multicultural single-parent families. So we will be discussing that, and we will also be discussing the human rights of the children of multicultural single-parent families in the educational field. And last but not least, there are matters regarding the basic rights and human rights of multicultural single-parent families in the process of obtaining a Korean nationality. So we will be discussing that also. Korea has a relatively short history of embracing immigrants. And although there were many efforts and commitments to enhance this issue, still there are many institutional blind spots that exist in Korea. And it is true that there's many bullying, assault, and death of children from multicultural families that are still occurring in schools, and multicultural single parents are experiencing limitations and restrictions in enjoying their basic rights. In 10 years, 20 years' time, the share of multicultural families will even rise, and we will see that we will have to make sure that these multicultural families do not suffer in the institutional blind spots, but get an opportunity to enjoy their human rights and civil rights fully. We have to eliminate all of these blind spots and transform Seoul into a sustainable and inclusive society. In order to do that, we have to make sure that we craft policies that allow multicultural single-parent families to not abandon their child, but to live with them together. We have gathered experts from all around the world and in Korea, experts in family policies, women's rights policies, and also multicultural family-related policies. We will be listening to their insight and wisdom today. So with that, I would like to introduce the first speaker, President Lee Young-ho, with a big round of applause.
Nice to meet you. I am Lee Young-ho. I'll be talking about the policy for and human rights of multicultural single-parent families and the president of Seoul Metropolitan Single-Parent Family Support Center. You've heard a lot about multicultural family, but when it comes to multicultural single parent, there is no law, even in the multicultural population law, or even in different laws. For immigration women, if they were married and then they became a single mother, then it is referred to as multicultural single parent family. Of course, if the person has not reported for the marriage, it could be regarded as multicultural single parent family. If the person is married to Korean citizens and make efforts to live in a marriage, or in some cases, these people would remarry Korean citizens. So such different types of life continue in Korea, and this is the fact of life. But if they cannot continue, if the marriage cannot continue, then the person must feel so unstable. That's the case for multicultural single-parent family. Single parents have to raise their kids together. They say a whole village. It takes a whole village to raise a kid. In Korea, we say it takes 6 people to raise a kid. So the parents, the grandparents, and etc. But for multicultural single parent, they don't have their parents. So they have to live alone and raise the kids alone. So the blind spot of the human rights for these people is to do with the nationality acquisition and extension of stay permit. But I'm not a human rights activist and I'm not an expert in human rights. So I try to identify the common difficulties that they experience, and in seeking for the support and ways for support, I'd like to find some solutions at this conference. Today, I'd like to talk about the policies and human rights of the multicultural single parents in the statistics. Secondly, I'll look into the legal system. And then I'd like to talk about the national acquisition and extension of a stay permit and their human rights as well. First, the statistics regarding multicultural single parents. It says multicultural single parents in statistics, but I couldn't find any data regarding multicultural single parents in statistics. So I could only make assumptions based on data. I'm going to focus on three materials. First is a survey on the public perception on diversity conducted by Ministry of Gender Equality and Family. So the various types of family, such as the multicultural family, single parent family, was surveyed in terms of the public perception. Multicultural family ranked #1 when it comes to the public acceptance. So it was 91.7%. But if they could accept the multicultural child as the spouse of their children, the figure drops to less than 80%. By age, it was 89.9% for those in the 20s. So the acceptance for multicultural families is expected to rise in the future. Secondly, the Statistics Korea did a survey on the multicultural population change. So the multicultural marriage is increasing, but the divorce among multicultural families is decreasing. So that's the conclusion. I can show you a graph. So starting from 2009 and 2019, there's a number of marriage. The number of multicultural marriage declined because of the regulation, but it is increasing again due to the Korean wave. Another graph shows that the share of multicultural marriage out of the total marriage, that's 10.3%, which is an increase by 1.2% compared to last year. Next, multicultural families' divorce rate. It's interesting because if you see the graph, excuse me, I didn't really touch the remote, but it just flips to the next page. If you see the multicultural families' birth rate, and then they looked into the marriage period before divorce. If you see inter-Korean marriage, there are a lot of divorce after 20 years of marriage, so after they raise the kids. But for multicultural marriage, the divorce happened when the children are young. It means that the multicultural single parents are normally young, and that a share is likely to increase in the future. So divorced multicultural single parents have about 8.6 years of average marriage year, and the birth rate is increasing from the multicultural parents out of the total birth rate. The third one is a 3-year multicultural survey by the Ministry of Gender Equality and Family. It says over 20%, but it is my assumption. So I calculated all the bereavement and the separation of the family and then divorce, and then the result is 26.4%. The reason for the separation and divorce, #1 reason is personality, and then we had economic issue, financial issues, and the abuse, etc. So after the divorce, in 94% of the cases, the father or the mother would raise the kids. What was interesting is that the multicultural single parents, and the 7.1% of them said that they find it lonely, and this is to do with the social relations. So when their divorce is separated, the social relations of multicultural single parent would be more vulnerable. Those who have experienced the social gathering over 60% said that they found it difficult to interact and meet people. And except for family, they do not have anyone to discuss with when it comes to their difficulties. So for nationality acquisition, about 46% of married immigrants acquired nationality, and the woman is about 48%. And after bereaved family, it's about 67%. For intent to acquire nationality and permanent residency, the people who have intent to they acquire nationality, some say they would give up on both nationality and permanent residency, but 58.5% said they would acquire nationality, and the 67.5% was bereaved single parents. So it shows how desperate these people are to acquire the nationality. So next, multicultural single parent support in our legal system. By the state, the law has the Single Parent Support Act and the Marriage Intermediation Business Act, and etc. And there is no provision regarding the multicultural single parents in our law. There is a provision regarding the multicultural family, but no multicultural single parent provision. Of course, there is a campaign for single parent support, but then this is regarding those who have acquired the nationality. So the Single Parent Support Act has been revised this year. Before, out of those foreigners residing in Korea, those who are raising kids after marrying a Korean citizen can apply for the support. So even if there is no nationality acquisition, the support could be made. So there should be a marriage between a foreign resident, foreign national and Korean citizens, but now that phrase has been erased, so the single mother can receive the support. So in terms of the support, the governments provide support, and then in the table you can see the range of the support starting from the child support and housing support. But this is provided for the legal parents and then mostly financial support. So there's no separated support for multicultural single parents. If you see the social welfare system in Korea, it is based on the application, so it is not automatic support. The applicant must make a visit to make application, but this is not easy for multicultural single parents. So let's look at the multicultural single parents support by Seoul Metropolitan government. There is a ordinance regarding multicultural single parents, and we have a Seoul Metropolitan Multicultural Single Parent Support Center. Starting from 2013, we've been doing a coordinator project for multicultural single parents, and we've been having a forum targeting this group of people. So we provide a legal service and legal system for multicultural single parents. We had a forum here, as you can see this in this picture, and we've been supporting for self-reliance group. And for multicultural single parents, we've been supporting this since 2019, and that group has turned into Global Single Parent Center in 2020, led by the President Hwang Sun-young. Through this single parent coordinator project, we've achieved quite a lot. I'd like to talk about that. So we have a senior single parent and a junior single parent. So it's a one-on-one tailored support system. So it informs all the different policies by the Seoul and then accompany the junior single parent if necessary. So our center fosters experts, and then those who received our training is granted with the right to act as a coordinator. In 2020, we have about 4 multicultural single parents who are acting as coordinators. With this conference, I actually looked into our achievement starting from last year. We have 24 multicultural single parents, and we provided about 6.6 services on average for each of those multicultural single parents. There was characteristics for them. First of all, they have a low income, and even if they are included in the scope of a support, they are not aware of it. Also, even if they are aware of the support and they would inquire to the relevant institutions, there was communication issues. So there was a lack of connection between the actual support that could be provided for them and the level of information that they have. Also, we have a life coordinator for multicultural single parents. Their activities included, first of all, that they would provide a service to confirm their legal status as parents. Second, housing support, such as LH or SH, would be reviewed for them. So there is the first characteristics that there is a lot of services provided to confirm the accessibility. And then there was services that would visit institutions with these people to make an application. There's other services like emotional support, but what's special here is that out of all the different services requested by them, there was no case, few cases related to nationality acquisition. As I mentioned, if you see the national acquisition and intend to acquire nationality, the rate was higher for those who are divorced out of those who are married. But there was no request to our center related to nationality acquisition. We didn't have any factual survey for the multicultural single parents, so it raises a question for us where we should begin. Nationality acquisition applies to all immigrants, but if you're a single parent, according to the current Immigration Act, is more difficult. The single parents immigrants can extend their stay permit while raising underage children. So the immigrants, marriage immigrants become single parents, and then if their children becomes adult, they don't have a stay permit. So this is a serious challenge for those people. Why did we not see this issue until now? Because they find it maybe too difficult to get by every day until the child becomes adult. So maybe they have to postpone the nationality acquisition. Or maybe they recognize this as a systematic issue and they didn't really think of applying it. Maybe those could be the issues or the reasons. As I mentioned, I'm not a human rights activist, but I have a chance to deal with these people. So to enhance the accessibility to the Seoul's systems, and I believe it's necessary to reduce the blind spots for the system. So to improve the inconveniences and then realize these changes, I believe that's something that we have to do. Being a single parent means a completely different version of life. One less adult leads to emotional, medical, educational, and housing shortages, or even lack. So we have to provide we have to have a separate design for your life. Most importantly, you have to have a housing and the basis for your living. So I believe the residence is related to your right to live. So I had an opportunity to look at the documents that you need to provide to acquire the nationality, and then I was really shocked to see that you are supposed to present a detailed reason for discontinuation of marriage. So if you have reported for your marriage and you were actually in the marriage, then it means the validity of the marriage can be confirmed. And why is it so unnecessarily complicated? That's what I thought. But fortunately, the law school at Seoul National University filed documents to improve the situation. So the rights to pursue happiness and rights to live as human beings, this can all apply to the married immigrants, and the parents and the children should live together and they have a right to do so. So these were the details of this complaint that was filed. I hope that this goes well, and I hope that all the regulations should be eased regarding the nationality acquisition, and the previous system that relies heavily on the Korean husband needs to be eased. So the self-reliance claim, which is in place in the US, should be also considered for implementation in Korea. Human rights issue for the multicultural single parents is an important issue. This is an issue of multicultural single parents in Korea, but it is an issue of the children with the Korean nationality. So I'd like to make a few proposals regarding this issue. First off, regarding multicultural single parents, we need a factual survey. We need data. Secondly, for married immigrants, the nationality acquisition process needs to be revamped for simplification. Third and fourth is something that our center need to do. At our center, we have the single parent life coordinator, and the multicultural single parents needs to be separated for the different system. And fourth, at our center, to support multicultural single parents, we need to identify our roadmap, and if necessary, we need to make an improvement. Fifth, for single parents, I believe that they need to voice their difficulties more because they don't have nationality. Some would say they are not our citizens, but according to the rights to pursue happiness under our constitution, it says for all citizens. But there is a human rights on the National Human Rights Commission Act. Also, there are other provisions under the act that this law can be applied to foreigners residing in Korea, so they should voice their opinions and rights. I also believe that multicultural single parents should say loudly that we are here raising our kids and our center will support them in the process. I myself sometimes need my mother and miss my mother even at my age. Those people who have to leave their home country and live in a foreign country and struggling to raise their children, I'd like to send my respect and words of respect as well. Thank you very much. So President Lee Young-ho of Seoul Metropolitan Single Parents Family Support Center, thank you very much for your excellent presentation. Next, we will invite researcher Lee Chun-yang from the Convergence Institute for Multicultural Studies from Inha University. Please.
Yes, hello. As introduced, my name is Lee Chun-yang. I'm a researcher at the Convergence Institute for Multicultural Studies at Inha University. I've been a researcher since 2015, and I myself am a marriage immigrant. I have been working at the Research Institute for the past 4 years or so, providing support to multicultural families, adolescents, marriage immigrant women, and single-parent families. I first became introduced in this topic in 2018 as I was preparing for my paper for the doctor's degree. And today I would like to introduce some cases of disadvantages experienced by single migrant workers without citizenship. This is to highlight the importance of obtaining a citizenship to enjoy human rights in the Korean society and to point out the institutional blind spots that currently exist. Before I go into the actual case examples, I would like to briefly touch on the current status and the historical trends. Korea, as a Confucius society, has long been believing that a marriage is a blend of the yin and the yang, and that it is a virtue that you have to prove for your parents. However, since 1990s, there has been difficulty for some Korean men in finding a bride. As such, marriage immigrants have been starting to come to Korea, and this has become a new social trend. However, because of many reasons, voluntary or involuntary, there have been family breakdowns where the family is taken apart. According to some statistics, since 2008 to 2019, there has been more than a cumulative 160,000 cases of a multicultural family broken down. As you can see here, this trend has started since 2008, and it was on the decline around 2011. But still, you can see that it still takes up quite a significant portion with 10.1%. In the case of Seoul, in around 208 to 211 for Seoul, around 22% of the total number of multicultural families were broken down. However, it is also noticeable that the mortality rate of the spouse has been increasing. Especially for males, it takes up 70%. This also means that the number of bereaved families or women who have lost their husband has been increasing. When the family is broken down or after losing her husband, these marriage immigrants have to raise a child on their own, and the percentage of a multicultural single mother raising the child has jumped to 94.9% in 2018 from 65.3% in 2015, which is a large hike. We also have to notice the fact that the total number of multicultural families has been increasing cumulatively, but still the interest or research into these families are lacking. And now I would like to touch on some research cases that we have conducted so far. This is a paper by Kim Gang-nam in 2016. These women have to avoid being in a precarious state by extending their visa, and they also have to obtain citizenship to be able to legally invite their family members from their native countries. But since they're suffering from a heavy level of work and they have to juggle child rearing and work and household chores and so forth, they are suffering from a double, triple challenges, and they're required to pass a very high level Korean proficiency written test, which makes it hard for them to obtain citizenship. This is also proven in a paper by Kim Hee-ju in 2018. And also in a paper by Choi Seung-in in 2012, if a wife divorces her husband before obtaining a nationality, they can obtain custody for the child, but many of these women are not in an economic circumstance to meet the legal requirements. The eligibility requirement is very tricky and the expenses are very high. So these women also, they have to pass a test that can be also very tricky and difficult. So many of the multicultural single parents, these women, find it very hard to take upon this challenge because they are already very busy in engaging in economic activities, and they also have less time to be educated or trained, and they have to teach themselves to pass this test, which means that them obtaining citizenship is near impossible. According to a paper by Choi Mi-kyung in 2012, if these people are not able to extend their visa and come to be on overstay, it's very easy for them to become undocumented residents. And in this very precarious life, what impacts their life the most is the fear that they might become illegal residents before they obtain the citizenship and might be deported from the country. And in a paper by Lee Seung-soon in 2018, in cases where they are not able to obtain nationality, they have to go back to their native countries, but they have trouble doing that because they're scared of the uncertainty that will be occurring when they return back to their native country. And there are actually some cases where they bring their child to their native country and return back to their home countries. And this is mostly because they're seeking a life with their child or to live with their children. If you cannot have custody in Korea after you divorce your husband, you have no option but to go back to your native country because you don't want to be separated from your child. A case in point is a case that happened in 2007. A Vietnamese woman reported the child, registered the child to the Vietnamese embassy, and took the child to Vietnam with her secretly without the husband knowing. And she said that if there was a way to live with the child in Korea, she wouldn't have done that. But the only way to live with the child was to return home to Vietnam. And this is why she ended up choosing to bring the child with her to her home country. So those were some case examples and the research that we have done thus far. And I try to show and highlight the difficulties that the women are currently facing. Now I'll move on to introduce some real-life cases where women were subject to disadvantages. In case number 1, it was a 34-year-old woman from Vietnam. She lost her husband due to an accident when she was 4 months pregnant, and the company of the father gave a compensation of 50 million Korean won, but this person concerned did not meet the legal requirements necessary to obtain nationality. And there was another case, a Chinese woman that was 35 years old who managed to obtain citizenship, who also lost her husband and received a compensation of around 150 million won. In this case, she was able to receive funds, livelihood funds, for her 2 children until they became adults. So this Vietnamese woman and the Chinese woman, they went through very similar experiences. In this case, she did not, and there was also another case where there wasn't a child involved, but still that person managed to receive compensations. But the Vietnamese woman, since she did not have citizenship, could not receive these benefits. She was not entitled to these benefits. I'm sure that there could be many differences depending on the case, but still we can see in this case that the Vietnamese woman was discriminated against because she did not have citizenship. Discrimination in itself is a problem, but when this Vietnamese woman lost her husband, she was 4 months pregnant, and although she was entitled to the compensation provided by the company, her family-in-law argued that they would first keep the money instead before the child became an adult. And case number 2 involves a single parent, a woman from Uzbekistan that is 41 years old. She was subject to domestic violence and she divorced her husband. She was very highly educated. She went to university and she has around 8 licenses, and she's also a very active volunteer, taking part in volunteer work. However, since she did not have citizenship, she had a lot of trouble in finding a career because her former husband ran a scam, committed fraud against people in Uzbekistan and had a criminal record. So this woman could not have a public certificate issued. So even though she had experience of working at police offices and running many part-time jobs in public agencies, she was intending to find a very stable career and a job, but because of that criminal record of her former husband, she wasn't able to do that. The third case involves a Russian woman. She married in 2009, and in 2011 she came back to her native country temporarily, but then her spouse filed for divorce on his own, and after that she has not yet been able to obtain citizenship. After returning to the native country in winter because of COVID-19, her return flight got canceled, and over the course of this process, the passport of her daughter was almost expired, so they asked to the consulate for help. But the daughter, since she was a Korean citizen, she was able to board the returning flight. But this woman that's concerned was denied access, so she almost was completely separated from her daughter. They managed to, at the very last minute, they issued an emergency passport and stayed in Russia for an additional 6 months. So they were technically not undocumented residents, but the daughter ended up not being able to go to school for the entire first semester. Case number 4 has to do with a Chinese woman who left her husband because of domestic violence. She said that she was very hurt and insulted by the abusive words of the staff at her former employer. They called people with their country of origin, which was very rude. These abusive words or expressions hamper and impacts the life of multicultural single-parent women very negatively. Case number 5 involves a Japanese woman who was not able to obtain citizenship because she couldn't pass the written test. There are many social integration programs that she could enroll in, but since her job is very busy and she has to juggle work and life, she can't manage to make the time for that, and she has trouble in finding relevant information online because her name is 7 characters, but the online websites only allow up to a 5-character name, so she can't join any of the websites, which is very frustrating. And it's not only that, but she can also not issue any public certificates at the unmanned kiosks. So we can see that these women are experiencing many inconveniences because of their precarious status. Because they have not obtained citizenship, it ends up that the minor children are listed as head of households and the mother is recorded under them. So until their children become adults, these foreign women cannot obtain a nationality. They have to simply become the guardian of their children, and when the children become adults, these women have to go back to their native countries. And even if the children become adults legally, there's also the question of whether they are completely self-sustainable, and if the citizenship-related policy is that complicated and tricky, it means that the guardians or these women cannot fulfill their complete responsibility as a guardian for their child. So you can see that this is an issue that is intricately related with child rearing, careers, employment, social rights, and so forth. So these immigrant women are faced with challenges like these, and also they are subject to many disadvantages. Before I conclude my presentation, I would like to introduce the dreams of the immigrant women that we came across while we were doing this research. I want to become a great mom. I want to give my child a very successful life. I want to open a small restaurant. I want to go to university. I want to open a farm. I want to become a cultural lecturer. I want to make furniture out of wood. I want to become an interpreter or translator. I want to work at a company. I want to become a Russian language teacher. I want to become a social welfare expert. I want to become a CEO. I want to become a writer. I want to do social volunteer work. This is my dream that I want to achieve someday. These single-parent immigrant women have moved to Korea as a result of a marriage, and then their family is broken down, and they are subsequently put through many difficulties. Still, they have lived in Korea for a long time and are a part of Korean society. They are taking part in the Korean community very actively, and they have the right to become a very happy Korean citizen going forward. So for social cohesion, social inclusion, and social integration of these immigrant women, and to help them and their child enjoy many social rights, we have to make sure that a special naturalization system is introduced and flexibility is incorporated into the system to enhance the quality of life. I hope that Seoul City will play a pioneering role in this area and set a prime example for all of the other cities to follow. And I also believe that the Seoul Metropolitan government, along with many family support centers, single-parent support centers, and local residential centers, they will join hands and try to gather an understanding on the current status and provide many relevant information, legal support, counseling, and other relevant services to multinational single parents, and also help them go through online courses so that they can deepen their understanding on obtaining citizenship. And also, I hope that we will take recognition of the social participation and activities of the multicultural marriage immigrant women and help them try and obtain citizenship through other options that are available for them. Thank you very much for listening. That will be the end of my presentation. Thank you so much, Researcher Lee, for your great presentation. I think the two previous presentations touched on the difficulties of obtaining a nationality and what a hard time these marriage immigrant women are going through in raising their child in Korea. So I would like to once again thank the two speakers for their brilliant presentation. Next up, we will move on to the panel discussion. So we have our two speakers here today and the four panelists who will be joining us for a panel discussion. First of all, we have Director Chun Young-sun from the Korea Hanbumo Association who will be giving a brief comment.
Hello, I'm a discussant, Director Chun Young-sun from Korea Hanbumo Association. I deal with the human rights and the life of a single parent living in Korea. So the association that I'm in is engaged in activities like this. With the Global Single Parent Center, we do cooperate and engage with each other, and we've been creating a network together. And under the theme of the policies and human rights of multicultural single parent family, I am glad to be joining the discussion here. While preparing for this discussion, I got to know more about the human rights issues of the multicultural single parents and their children. because I had an opportunity to study, and then I realized how serious the issue is even more. I believe that we have to pay more attention to this issue and then make more efforts in the future. Regardless of the race or the nationality, we should never discriminate anyone. On this land, everyone should be equally treated, and the social atmosphere should be created to that end. That is called multicultural society, and nobody should be discriminated because of the family background, and the diversity of families should be respected in our society. Multicultural single parents have to raise their children outside of the marriage, so it has complex issues. In a multicultural society, the diversity of families should be respected, but that's not the case for multicultural single parents. According to the Single Parents Support Act, the target of the support, it has a special conditions and special scope. So among the foreigners residing in Korea, those who are married to Korean citizens, so this marriage is a precondition to be subject of this Single Parent Support Act. But as it was mentioned by President Lee Young-ho, on October 22nd this year, the marriage was excluded from this provision. But regardless of the marital status, any single parent with a child with a Korean nationality can be subject to this act. So in Korea, the family is based on the marriage, and the diversity of marriage was not respected in Korea before. And it is fortunate that the act has been revised to reflect the social diversity, but that was a reality of Korea. It was mentioned by the two speakers that the reality of multicultural single parents are quite difficult, but as the longer the multicultural immigrants stay in Korea, there is a higher rate of divorce and more single parents. We talk about single parents in Korea and their lives a lot, but for single parents in Korea, they find a very difficult situation in terms of their financial status and employment status, and their labor right or the housing issues are not secure. And for multicultural single parents, it is going to be even more difficult in Korea. Those who can receive the benefits from Single Parents Support Act, they have a difficulty in access to information, and there's a limitation in terms of the communication, so there's a blind spot there. How can the government and how can our society resolve this issue and prevent this blind spot? I believe after today's discussion, there should be more in-depth discussion. I talked about the family issue because to talk about the children issue, if you see the children of a multicultural families, there is a linguistic problem. It may be difficult for them to have a communication properly, and because of the cultural issues or adaptation issues, the children of multicultural family say that it's difficult for them to socialize at school or even attend the school. I don't know if because of these difficulties, but at school there is a lot of violence, and these violent cases are quite serious. According to a survey, more than 10% of students experience violence at school. I believe there are so many cases that are still hidden and not revealed. Last year, I believe, at a tall apartment, a student fell from the tall apartment building while trying to avoid the violence or violent peers. This was not even a big social issue at the time. It just disappeared from the news, which is so unfortunate. But I believe it's necessary to emphasize these issues so that our society can pay more attention to these issues and make efforts for change. These multicultural children find it difficult to socialize at school. they may face a discrimination from students or teachers, so they may give up advancing to the next level of education. For young children, child care services are not enough or even completely lacking. We talk about the child care for Korean children, but child care for single parents or even for multicultural single parents, there's a lot more limitations, so it is a more serious issue for them. There's education, housing issues are all raised as serious for these types of families and single parents. I mentioned about the multicultural families, and then if we look into the multicultural single parents, as I mentioned, the longer they stay, the parents become more aged, and their income level is low, so the financial basis is unstable. So when multicultural families divorce, in many cases, the married immigrants raise the kids. That's around 95% of the cases. And 95% of the cases are women married immigrants. So because they're foreigners and women raising their children in Korea, so it is obvious what kind of situation they have to go through. So financial issues and cultural issues and their vulnerability, we can just imagine that this is going to be very difficult for them. Secondly, they're multicultural and single parents, so they're exposed to prejudices in twice or 3 times more than in normal cases. They're requested for completely some documents that they need to prove themselves for their low income or their status. And it was mentioned in the presentations for the national acquisition or obtaining the nationalities, you have to state why you divorce or decide to discontinue the marriage. So this is a privacy issue. Even the children or are exposed to prejudice at school or during their course of life. If you see the presentation details by President Lee Young-ho, there was a survey on the personal acceptance of various types of families. And one of the questions was, are you willing to accept someone from the multicultural or various types of family backgrounds as the spouse of your child? And for the multicultural family or the single parents, or there were different figures for the acceptance level. But for multicultural, you can see the prejudice is quite high. I'm a single parent myself. We actually feel such prejudice in Korea. If you say you were raised by a single mother, then when you want to get married, there are a lot of prejudices against it. I believe the actual figure is going to be higher than the figure in the survey. Another thing is that it's more difficult for them to receive the child support if you're a multicultural single parent. Even the Korean single parent, they come across some legal issues and limitations, and we are changing those laws, but still, it is difficult to actually get a child support from those who are not willing to pay. If it's multicultural single parents, it's bound to be more difficult, and it's more difficult for low income families. For low income single parents of a monthly income of less than 1 million won, only 8.8% can receive the child support. If you are in an unstable employment, then you don't have time to keep insisting for the enforcement of the child support, so you're bound to give up. So when you're raising a kid without the child support, this may actually threaten your rights to live, and this is true even for the right of children to live. So the child support is a serious issue. Also, the emotional support system is quite weak for many multicultural single parents families. Many of these parents say my child is very unstable emotionally because the multicultural single parent has to raise a kid alone as the income earner and doesn't have time to take care of a child and they cannot provide support to a child, and child has to be alone all the time. So due to the COVID-19, recently I had an opportunity to provide support to single parents in Daegu and Gyeongsang province, and there were so many multicultural single parents applicants. I went to Daegu city myself and met them, and so many multicultural single parents said they welcomed me so warmly, and then they wanted to talk to me after the meeting. So I realized how isolated they were in the COVID-19 era. Financially speaking, that is true, but because of COVID-19, they couldn't really move around, and all the centers have closed. So they were isolated with their kids, and then even their social interaction is decreasing. And if you have a child with a disability, then it's so frustrating. One person told me that she even considered giving up on her life, and she often thinks about it. So this is a complex issue. Even if you're healthy and a single parent, it's still difficult. But as a multicultural single parent raising a child, this is such an unfortunate situation. In connection to this, in a crisis, those who are in a difficult situation, they have to face even more hardships. Many single parents lost their jobs because of the COVID-19, and they find it difficult to make their ends met, and their relationship with the child is also precarious, and it is even more difficult for a multicultural single parent, and we could confirm that through our activities. Also, because children do not go to school, there is a learning gap for the children. So how are you going to do that? If you are fluent and if you have good conditions, then you can hire a private tutor or send the kids to the private institutions. But if the child has to be left alone and for learning, then the learning is actually not happening at all. So there's the issue of these children lagging behind. And how are you going to narrow the gap after 2 or 3 years? That's a major concern for us. So the things that I heard from single parents was that because their life is experiencing some difficulties, it's difficult for them to pay the monthly rent, and they don't have any choice but to go to the facilities. And these facilities, of course, may provide housing, or they can resolve immediate issues. But we have to look into the significance of these facilities in terms of its meaning to children. Does it guarantee the privacy for these children? This is an issue that we have to consider. And the life of a single parent and even the child of a multicultural single parents are directly affected by the life of their parents. And it has an impact on their life at school, and it is a huge obstacle for them growing up as a healthy adult. Considering the discrimination against the family is also an issue. Just because it's a multicultural single parents, it doesn't mean that they have to endure all the bullies or prejudices in our society or even at school. This is a serious issue that we need to really consider. The Anti-Discrimination Act is currently undergoing, and we are preparing this. And then we have other amendment bill to the laws, which is presented at the National Assembly. I believe we need more efforts to change these provisions one by one. No matter what kind of circumstances they are raised in, they have a right to live safely. Even at school, children of multicultural families need to have a good school life, and then there are many supports and the programs provided for them and to that end. But one thing that we have to remember is that there is a certain sense of distance between the multicultural family, between the Korean children. Some say it is a division between these two groups, and then it could lead to isolation of multicultural students. So we need more various programs developed to allow these multicultural students to be integrated with the Korean students at school. Seoul cities single parents support center is doing a lot of educational program. I believe that we need a lot more teachers, or the teachers at the nursery or the civil servants need to receive a lot more diverse educations and trainings, and that should be settled more in our culture and our society. Lastly, I'd like to talk about the rights of a child. According to the UN Convention on the Right of a Child, regardless of the nationality, we have to protect all children. So at school, as it was mentioned by the president of Yeong-ho, she said that there's no statistics, and statistics is extremely important. And I believe that we need more monitoring of what is going on at school and what kind of discrimination our children are experiencing and how we can improve the situation. We need more countermeasures regarding those issues. It was also discussed that for child support, I don't believe the amendment of the law is not really effective. I believe the child support act should be newly implemented to guarantee safety for all children, for more pleasant living condition. I believe the housing right should be guaranteed for all children, not just the facilities. We have multicultural centers and various institutions, and they have different programs and supports. The Global Single Parent Center, who are engaged in the single parents groups, need to go beyond just providing a program and have to insist rights of these people. And when it comes to the issue of children, we have to see if these children are really happy in their lives, and this is something that we need to look into in more detail so that we can improve these issues and we can seek for better ways to make an improvement with the whole society. And we will continue to pay attention to this issue as well. Thank you very much. Thank you for your excellent comment. That was a discussant, Director Chun Young-sun from Korea Hanbumo Association. As the director has just mentioned, the multicultural single parents are in such precarious situation, and the children of this family can grow up well so that they can be a good citizen for our society. And I believe we need a reform and a revamp of our system and regulation. Next, we have Research Fellow Kim Hee-sun of Korea Women's Development Institute. The floor is yours, please.
We have heard a lot about marriage immigrants, multicultural families, and a lot of support programs to help these families. So there is a perception that these immigrants, even if they don't acquire a nationality, will enjoy a similar quality of life as other typical Koreans, or even they're entitled to special treatment or benefits that the Koreans don't get to enjoy. But as a matter of fact, the vulnerable link in a society is revealed in the time of a crisis. And I think this year, was a very good case in point. This crisis, this pandemic, has revealed the vulnerability of marriage immigrants, especially women who are no longer with their husband. So I think we have witnessed many difficulties and vulnerabilities that they are going through this year because of this unprecedented global crisis, the pandemic named COVID. In the initial stage, when the government was giving away free masks, I'm sure you all remember taking your ID card, national registration card, or your passport to pharmacies to get masks. But the marriage immigrants, I think from 2017, due to an enforcement decree, they can now be recorded on the National Register, but they don't technically have an ID card issued, so they don't have an ID card with them. So even if they are required to bring their ID card with them, they can't because it doesn't exist. The law specifies that they receive health insurance coverage and they have the right to purchase the masks, but in reality, they can't because they don't have their ID card with them. And regarding the disaster relief funds, the policies regarding these funds are very different depending on the local government. Many of the local governments did not include marriage immigrants in the coverage at first, but then they revised the requirements to provide them with the funds. But I still believe that not all local governments are giving these benefits out to marriage immigrants. So this led me to think about what kind of a social status are these women enjoying in Korea. They are actually located in a very vulnerable and precarious status, and they might be a weak link in the Korean society. Some people believe that out of all the foreign immigrants, if you're a marriage immigrant, you get entitled to many of these benefits, but yes, I do believe that the national basic livelihood security system is only provided to the marriage immigrants out of all types of immigrants. But it's not true that marriage immigrants are entitled to all the benefits that they need to lead the basic livelihood in Korea. That is not true. Just to be straightforward, if all Koreans, as long as they suit a certain level of requirements, are entitled to all the benefits, but marriage immigrants are not. They have to be pregnant of a Korean child, or they have to be rearing a Korean child, or they have to be supporting a Korean parent or a parent-in-law. So they have to be connected to a Korean by blood in order to be entitled to these benefits. And when they're divorced, they are entitled to these social security benefits only when they are rearing a child with a Korean nationality. Of course, there could be some exceptions guaranteed to the marriage immigrants. These exceptions are specified in the law, but still it's not enough to give them full welfare services. People believe that superficially marriage immigrants are entitled to very special treatment, but when you come to think about it, it's not benefits for them, it's benefits for the Korean child that these women are rearing. And you get a F6 visa issued when you marry a Korean. So even when your marriage is no longer valid, they can still have an F6 visa. F6-2 applies to those who are rearing a Korean child. F6-3 applies to people who have either left their husband or divorced their husband or lost their husband due to an accident because of an event that is not attributable to them. But what we should focus on is that the F6 visa assumes that the woman is raising a Korean child. But there's a catch here, which is that if the child becomes an adult, the moment the child becomes an adult, the marriage immigrant can no longer stay in Korea with the F6 visa. They have to acquire another status. But if you have a job or a stable career in Korea, you could probably acquire another visa, but I understand that these cases are very rare. Many of the marriage immigrants want to acquire permanent residency or obtain citizenship, but in the past, it wasn't that difficult to apply for a permanent resident status or nationality, but over the years, the policies became very tricky and tighter. So now you have to meet a lot of economic requirements and Korean language requirements and so forth. But the economic requirements are very stringent and it's very hard to meet because the mean income of the household has to be more or above the average GNI per household in Korea. But in most cases, these multicultural single parent families are leading a livelihood with the income of the single parent alone. So it's very hard to meet this requirement. So in most cases, if you've divorced these marriage immigrants, they're having a hard time leading their day-to-day life and getting by. So in most cases, they can't meet this economic requirement, and because of this system, if the child is a minor, the mother can acquire a residential status as a guardian of that child, but once that child becomes an adult, the residential status of the mother becomes very precarious. So this is something that we have to solve right away. I remember last year in a TV program, it featured a 18-year-old child in a multicultural family, and the mother was a Filipino, and the child, 18 years old, was about to come of age and become an adult, which is something to celebrate. But this meant that the mother no longer had a legal status as a guardian of the child. So the child was scared that the mother would be forced to go back to the Philippines. So I think many students of the Seoul National University Law School watched the program. They felt that there is a problem with it, and I think that they filed a petition to the Human Rights Committee. And I, for one, learned many lessons and felt many takeaways as I was looking at that TV program. It's very cruel to only allow marriage immigrants to acquire a residential status as long as their child is a minor. This is indeed an infringement of Article number 10 of the Constitution, because according to that article, every human being is entitled to the right to pursue happiness. And this is, in a way, very scary because you can only reside in Korea until your child becomes an adult, which means that we're not acknowledging all the time and effort that the person is putting in to raise that child until he or she becomes an adult. We are simply treating them as a guardian or a caregiver. This is a very outmoded perspective that we're forcefully imposing on women. I believe that there's a point here. This is something that the Korean society has to mull over seriously. I think there would be many cases where the child becomes an adult and the mother no longer gets to extend her residential status here, so they're forced to go back to the native country. I think these cases will increase in number going forward, so we have to immediately prepare a solution to this. And I think, personally, I believe that we should grant permanent residency or to people who have raised their child until they become an adult, or at least we should be able to lift the requirements significantly for these marriage immigrants. But since it could take some time until we build a social consensus regarding this, and laws and regulations cannot be amended overnight, so at least we should try and adjust the age of the child so that the marriage immigrants could extend their stay for a while longer. And I think we should break this very old perception, and we have to respect these women and give them the respect that they deserve as a inclusive society. And I think that taking this opportunity, the Seoul Human Rights Conference and many of these events highlight the importance of this and provide us with a platform to discuss this very important issue. So how should we approach this issue of the residential status of marriage immigrants? This is something that we have to think about seriously in the years to come. Yes, thank you for your brilliant comment. You actually took the words out of my mouth. I feel the exact same way with you. The next comment would be made by a single parent, as a matter of fact, Ms. Ho Sol-hwa from the Global Single Parent Center.
Hello. I'm a student now, so this is an exam period, but I can be here thanks to the consideration of the professors. They are not here, but I'd like to extend my gratitude for them. I was under great stress even from the pregnancy period. I went to a hospital emergency room about 3 times, even after the childbirth. I was with a close sister for about 10 days. She was a victim of violence. And then she had to send their kids for adoption right after the childbirth. And then she went back to the center, and then she committed suicide. When I heard about the news, I was so shocked, and I felt guilty because maybe I felt that I should have consoled her a bit more, then maybe this has not happened. As only half parents and looking at the kid, I felt very sorry for the child. When you consider a long period of your life, the child is young, and I may not be able to work, and I might starve to death. So my mother, who was in China, she applied for tourist visa to come and visit me to take care of a child, but she couldn't get a visa, so it was just a waste of money. I am a foreign national, so I couldn't invite my mother to take care of my child. And because I couldn't entrust my childcare to someone else, I couldn't work, and I couldn't pay for my bill, I couldn't pay for the food, so it was frustrating every day. I felt like I was just waiting to die. I had to pay rent every month. And no matter how much I saved for food and clothes, how long I could endure, I wasn't sure. At the supermarket, I had to save even $1 to make my ends meet. I had to register my child for birth, but after a month I gave birth, I had to go out in a cold winter to go to Myeongdong, Yeouido Family Court, and all the immigration office as well, and the district office. I had to go around to prepare for all kinds of documents. I didn't know where the district office was. I didn't even know what the residence office was. To apply for the birth certificate, it was really difficult, and even for birth registration, I needed documents from the hospital, so I had to carry my baby to visit all these different institutions to prepare for the documents. When I applied for the nationality of my child, I was not given the nationality because of the requirements. To go out of the house with my baby, I had to it was really difficult because I didn't have anyone to ask to take care of my child, and it was even a luxury to eat 3 meals a day. I didn't know what kind of documents I have to prepare. And I couldn't even sleep at night before I have to go somewhere to register the birth. And it was so frustrating to fight for the birth registration. So I asked for help here and there, and they asked for the submission of documents. But because I'm a foreign national, and it was so difficult to issue the documents, even for the documents, I had to wait 40 or 30 minutes because I'm a foreign national, although it takes only a few minutes for a Korean national. Because of a construction work at the house, I didn't have anywhere to go, and I applied for the housing facilities, but I couldn't enter because of all the documents that I had to prepare. And I was running around here and there to enter the facilities and calling here and there, but it was all in vain. There is something that I forgot to mention. I'm a multicultural single parent, but I'm also multicultural unmarried single parent. So compared to other single parent, it was more difficult for me. For even a more stable life, I wanted a protection by somewhere or someone, but the police didn't allow, and I had to do a lot of things. And I wanted to work, but even even when I was working, I would just lose myself. Sometimes I would get forgetfulness because everything was just too much. Applying for housing was really difficult. My kid was underage, and I'm a foreign national, so I couldn't apply it online. And the frustration became a part of my daily life. I always had to explain my situation for maybe like half an hour or an hour to make people understand my situation. The housing condition was so bad that my child fall ill, and I went to the clinic, but it only got worsened. When I went to the clinic, there were so many children, and I had to wait for such a long time. And even at the hospital, when I get a prescription for medicine, I had to wait for a long time at the pharmacy. The child went to school and was making friends. And one day, my child said he went to the private institution, and the teacher at the private institution rang me. And then the teacher said that my child had an English test because my kid really wanted to go to the private institution, but I didn't have enough job, and I still had to. I still had the financial difficulties, so I had to come up with excuses. If my child wanted to study, I'd like to commend it, and it's my responsibility to send my kid to a private institution, but I couldn't do that, so I felt really bad as a parent. And then my kid applied for a multicultural football class, but because of COVID-19 and I didn't have a private transportation, so I couldn't really send my kid to the football club. And my child entered elementary school, and I got a job. And I promised that my child promised that he would go to the after school, but he wanted to visit me, and then we couldn't meet because I was still working. So my kid got lost, and then I found him luckily because of the help of a stranger. On a rainy day, I didn't have any money to provide food, so I had to leave my child alone and come out to work. And my child left a facility to find me crying in a rainy day, so I had to leave the work to meet him. In winter, it was even raining in Korea, and my clothes got soaked in rain. I couldn't really take care of myself after pregnancy, and then I was feeling a pain on all my body, and I got a flu on the day. I took all the medicines after that, but I got seriously ill, and I couldn't even get up for 1 month and couldn't work. We were living in a house full of mold, so my parent and my kid have a respiratory issue, and when I recovered, I lost my job. My kid went missing several times, and so many times I felt so stressed out because of this, and I called the police several times because of that. And on one occasion, I was riding a bicycle to try to find my kid, and I had an accident. Should I blame myself, or should I blame my child, or should I blame my society in all of these difficulties? It may be when I am talking to my friend while writing this document, then we are reminded of many incidences. I even ended up using all of my savings because I couldn't work during the pregnancy, and because I had to find a cheap house, we end up in a house with so much mold. And because of this bad housing conditions, we get so many diseases and depression and all the stresses, and our daily life became even more difficult. And this is such a vicious cycle that we found ourselves in. So many challenges and the challenges that I will face in the future made it impossible for me to plan for the future. I had to focus on a daily life because there are so many challenges that I have to overcome every day, and I didn't see any hope for the future. If you're those elderly people with dementia would experience some depression. Same for me. When it starts to get dark, I start to have a panic attack, and I experienced that myself. In addition to the panic attack, if I'm in an elevator, I find it difficult to breathe. So that's another type of a panic attack I have, because I have so much work to do. I always feel unstable and insecure, and I cannot take a rest. And I want to resolve all of these challenges and issues, but because it does not actually happen, I'm always thinking about so many things at the same time. As a parent raising a child, I try to communicate with my kid as much as possible, but my nervousness in a daily life was directly transferred or transmitted to my child. As a parent, I took several courses to raise my kids, and I tried my best to raise my kid, and even if I try to communicate with child in a nice way, but sometimes I cannot help but to scold my kid, and I cannot help but to feel really guilty for that. This is not just for my child. If there is any mentor who could lead my child or other children in the similar situation in a healthy and a better way, then they would grow up as a healthy adult. And this is a system that I would really need for the future of my child and for the multicultural single parent. I always think of that sister that I used to be close with who had to commit suicide, and that's why I decided to study for the child welfare and the welfare system to help myself and to help other single parents and multicultural family. I had to study, so I tried to receive the national scholarship, but because I'm a single mother and a foreign national, and I'm in a desperate need of the scholarship, but the answer I got was that it's not really related to my situation. But for my dream and for the welfare system of the multicultural single parents, I have overcome many difficulties. And even in the COVID-19 era, I continue my study at the graduate school. I am here not to ask for your sympathy. All of these situations apply not just to me, but to many people. People are dignified existence. We have a right to be free from others' prejudices, and we have a right to live with our children in a safe environment. All the foreign single mothers they have met are amazing, and they sacrifice themselves for their children, and they're devoted mothers who sacrifice a lot for their children. Now, I'm working as a coordinator at the Seoul Metropolitan Single Parent Center. Also at the Global Single Parent Center, I've been working as a member for 6 years. In Dongdaemun District, there's a self-reliance group supported by the Seoul Metropolitan Government. I'm leading the group for 3 years. A scholar said the issue is related to all the complicated emotions and issues, and all of these issues cannot be resolved by only an efforts by individuals. So this issue needs to be resolved as soon as possible so the foreign single parent and children can live in a safe environment. Thank you for listening and thank you for your attention. Thank you very much. She told us about all the difficulties that she faced, and it is really not easy to do so. Thank you for your courage. Thank you for joining us here at the discussion. Thank you very much, Member Ho Sol-hwa. Next, let's invite Kang Sung-ho, Team Leader of Multicultural Family Team of Seoul Metropolitan Government. The floor is yours.
Hello, my name is Kang Sung-ho. I'm the team leader at the Multicultural Family Team of the Seoul Metropolitan Government. I carefully listened to all the presentations and the comments, and I was able to learn much about the difficulties faced by multicultural single parents. I would like to briefly introduce the policies of the Seoul Metropolitan Government to support multicultural families and single parents, and the future direction for our policies. First of all, there are the multicultural family support policies. In order to support the stable livelihood of multicultural families, Seoul Metropolitan Government is operating diverse support centers, and we're also providing support for employment and childcare. We're also running and providing support for the operation of the Multicultural Family Support Center. I'm sure you all know, but we have basic programs, special programs, various communication programs to enhance gender equality and human rights and social integration, and to develop basic awareness and understandings. And also for special programs, we're doing case management, interpretation, and translation services, providing support for bilinguals, and also support for language development, linguistic development, and other additional services. And we're also running a special venue for communication and mingling, and we're also trying to help marriage immigrants by supporting them to enjoy many multicultural, friendly cultural activities in their region. And also we're supporting the migrant women, and we're supporting their basic livelihood. To support those at risk or those who are leading a precarious livelihood, we're providing counseling, medical, legal, and interpretation services to migrant workers, women in Seoul. We're also helping them with employment, child caring, child rearing, and capacity building. We're trying to help them become economically self-sustainable by helping them find a job. We're running educational programs, employment programs, online job exhibitions, and we're also providing child rearing services to ease their burden of raising a child. And in order to help and develop the educational abilities of the children of multicultural families, we have various programs regarding their education, career finding, and etc. Last but not least, in order to add vitality to the multicultural family community, we're running regional special programs to help them enjoy musicals or other cultural events. We're selecting those to enjoy those services through a public applications, and we're also providing language services in their mother tongue. And next up is Seoul City's single parent support policies. They're mostly targeting low-income single moms or single moms who were subject to domestic violence. In Seoul, there are various single mother, single parent, family support facilities, including the support center. There are 27 facilities. We're providing welfare benefits to these women. Specifically, the Ministry of Gender Equality and Family is providing these benefits, and Seoul City is also providing welfare services following the same standard. Especially for single-parent families with adolescents, we're trying to provide funds for child rearing and basic livelihood funds. And next is our support plans for multicultural single-parent families that we have in mind for the future. I think there are many things that we have to consider, and from what I've heard until now, it seems that depending on the Multicultural Family Support Act or the Single Family Support Act, the eligibility requirements, we were able to include single moms in the eligibility scope, and I think this is a very impressive feat that we were able to achieve with our collective efforts. So this is very encouraging. And the Multicultural Family Single Parent Support Act, before this act came about, we provided benefits to those who are married to a Korean who are raising a child in Korea, but now we have erased the phrase that goes married a Korean national. So I think this law will become effective in 6 months' time. When the law is officially implemented in April next year, I think we will then be able to pursue the amendment for the enforcement decree as well. So I think we have now set the details straight regarding the multicultural single families relatively. And now what we have to do is we have to translate this into actual support programs on the ground. So what we can do now is to, as I've heard earlier, there are those people who are eligible for those support programs are actually very busy earning a living that they can't find the time out of their schedule to attend these programs. And also, we have to inform them through promotional activities and let them know that they are entitled to these benefits. We have to ramp up these efforts. And also, going forward, I think Seoul City has to link the multicultural family support projects and single parent support projects to provide more comprehensive services to multicultural single-parent immigrants. And I think the biggest challenge for them would be regarding the residential status. Regarding this matter, we have to have a lot of consultation with the Ministry of Justice. We need conversations, communication to try and build a more favorable environment for them to raise their child in Korea. We have to take this into account, try and acknowledge their contribution in raising the child until they became adults. So in recognition of their hard work, I think we should probably make a special provision or an article to lift certain requirements. The multicultural single parents are indeed a valuable member of the society. They are part of our society. We have to respect them and take them into consideration. And Seoul City will be fully committed to try and provide them with the best services available. Thank you. Thank you for your great comments. You said what I wanted to hear, exactly what I wanted to hear. And when these marriage immigrants are trying to obtain citizenship, it's a very difficult journey, actually. They have to take 5 tests, and then they have to do another interview, and they have to earn more than 3 million Korean won monthly. So under these very difficult situations because of COVID, even a typical Korean citizen would have a hard time earning 3 million won, and you have to have a total property of over 30 million won. I think as parents, we should not look at their financial ability or their knowledge, but whether or not they can be a loving parent for their children. So with that, I would like to move on to the Q&A session. We don't have much time, so we'll just receive 2 questions. We have actually collected some questions in advance through YouTube. So thank you, moderator, for your hard work. I have a question. Many centers and organizations are running programs mainly rather than, I'm sorry, the letters are too small. I have to zoom in. Yeah, you should probably, rather than running just simple programs, shift to a more tailored approach. How do you think we can achieve this? Yes, I have a lot to say regarding this question, but I would first like to hand over the floor to Ms. Lee Hyung-ho, the president of the Seoul Metropolitan Single Parent Family Center.
Yes, so from what I heard, for single parents and multicultural parents, there should be tailored services because they are minorities of our society. I do agree with that. We need a tailored programs for them. At our center, as it was mentioned before, we have a single parents life coordinator. So this is a one-on-one tailored program and services provided for single parents. We have a multicultural coordinators, multicultural single parents coordinators, and in the 2 years, multicultural single parents received our services, and the number of parents who received our services 160 and over. So far, we focused on the single parents coordinators, but by different fields, such we have coordinators who specialize in housing support, also a coordinator specialized in confirmation of the legal parents, also coordinator for child support. So we have different fields for coordinators. For this conference, I was thinking that there must be some unique difficulties for multicultural single parents. So maybe we can create a field specialized for them. In fact, they find it difficult to communicate. Also, our coordinators, activists, when they meet multicultural single parents, even if they join the facilities for housing, we have to accompany them to show around, and we can maybe write the application together. Also, when they're allowed to enter the facilities, we have to be with them for moving, and if they need any house appliances, then our center have connected them with different centers. Of course, it's necessary for them to have a center that they can rely on rather than multiple centers they have to go around. So maybe a specialized coordination course or maybe support roadmap can be established and developed. So that's an idea that I have. I don't know if that could answer the question. Thank you very much. The Global Single Parent Center has provided a manual in 7 different languages, and we have also discovered households in crisis to provide help. In the process, we have cooperated with the Single Parent Family Support Center to help those multicultural single parents at risk. Also, we proposed the policies together, and so far we have amended or created 5 different policies or so. Multicultural single parents without any nationality, if they want to acquire nationality, they can have responsibility as parents, and they have good attitudes of not giving up their child. And I hope that there could be a new criteria for giving out the nationality for them. So let's move on to the second question. So for the Multicultural Support Center is being integrated for the Healthy Family Support Center. Is there any issue in that? Let me answer to that question. For now, we have a health and a family center, and this is being integrated with Multicultural Support Center. I believe the Multicultural Family Support Center, in terms of going into direction of a healthy family, in terms of the integration of 2 different centers, I do agree with it. But in the process of integration, multicultural single parents are not included in developing the program. I'd like to ask them to not develop programs for yourself and don't just assume that this would be necessary. I hope that you can develop programs that would be actually necessary for multicultural single parents. The Global Single Parent Center is in the current status because we provided help. Those people are actually needed. If not, they would not be with us. We could have not voiced with one mind. Whether it's understandable or not, we try to provide help that they need, even if it's not really included in our regulations. We would recognize the blind spots based on their own needs, and we would try to reflect that in our system and our policy. And I think that's the direction that we have to go in the future. Even at the Human Rights Conference, we have discussed various issues, and through these opportunities, we have identified the issue of nationality acquisition. So I hope that this issue can be resolved in the future. We don't have much time left. Do we have any comments from speakers or discussants? Anybody? Yes. So the director of Korean Hanbumo Association, maybe make it brief. So there was a discussion on the integration of the Healthy Family Center and the Multicultural Family Center. Regardless of which center, I believe the participants should be the main agents. The President Hwang Sun-young just mentioned that we should ask for the opinions and the needs of those who actually need the help. And I agree with that 100%. Rather than just advertising the program after you create it, you have to reflect the opinion of the participants, and those participants should actually lead the program so that in the end, those participants can be operators of the program or the leader of the programs. I think that would be the most ideal and the most necessary way. Same for the single parents and multicultural single parents. They are minority and they're the vulnerable group in our society. And we recognize them as someone that we always need to provide help by the government. But if we skip those people who actually need help, then it is not desirable. So they should actually be able to lead the programs, and they have to request their demands. They cannot just request without participating. So they have to come up with various ideas, or they have to voice their desires or opinions so that they can create the programs together. When that happens, I believe the welfare paradigms that we have will change, and I believe the participants should play a leading role. Thank you.
I think you raised a very good point. I hope that the world will increasingly be driven by the participants. So I think we should bring this session to a close. Thank you, everyone, for your time. Thank you, moderator. That marks the second session of the general sessions. It was indeed a very enthusiastic and heated discussion. Through the discussion, we were able to picture the way forward by our multicultural, single-family policies. I would like to thank the moderator, Hwang Sun-young, and Lee Young-ho, Lee Chun-yang, Chun Young-sun, Kim Hee-sun, Ho Sol-hwa, and Kang Sung-ho once again for their participation in the session. So with that, we would like to close the second general session. And after a short 30-minute break, we will resume at 3:30 with the third and final session of the day. And also, don't forget, there is an event that we are holding. If you haven't uploaded your picture yet, there's still a chance for you to apply. Please join us through the third session. Take a picture of yourself attending the conference and upload your picture on social media with a hashtag. And if you can also prove that on the official website, we would be selecting 100 people who will be receiving free coffee coupons as a gift. So, as I mentioned earlier, we will see you again shortly.
여러분, 뭐 하고 계세요? 저랑 같이 서울시 인권 정책길로 산책 가실래요? 서울시는 2012년 팀 단위가 아닌 과 단위의 인권 담당관을 신설하고 서울시 인권 기본조례를 제정한 것을 시작으로 전국 최초 시민 인권 보호관 제도 도입 운영, 인권위원회 구성 운영까지 시민의 인권 보호와 증진을 위해 제도적 기반 구축에 있어 선도적인 역할을 수행해오고 있어요. 과거에 있었던 잊어서는 안 되는 우리 인권 역사의 상징적인 공간들에 이렇게 도장을 꼭 찍어놓고 그 역사를 시민들과 함께 걸으며 기억하고 있죠. 그리고 현재 일어나선 안 되는 인권 침해를 예방하기 위해 철거 현장 인권 지킴이단이 시민들 곁을 지키고 있고요. 또 서울시 행정에서 인권 침해가 있었다고 판단되는 사건에 대해 시정 권고를 할 수 있는 시민 인권 침해 구제위원회가 인권 침해로 인해 고통받는 시민의 목소리에 늘 귀 기울이고 있습니다. 든든한 시민 인권 보호관이 언제나 기다리고 있습니다. 서울시는 국내 최초로 시민이 인권 침해 및 차별 사건에 대한 결정 과정에 직접 참여할 수 있는 시민 인권 배심원제를 도입하여 시민 스스로 인권을 지킬 수 있도록 돕고 있습니다. 서울시는 각 분야 인권 전문가들과 함께 앞으로도 시민의 인권을 위해 계속 걸어나가겠습니다. 서울시는 서울 인권 컨퍼런스를 통해 모든 시민의 인권이 바로 서는 행복한 사회를 꿈꾸며 인권 행정이 나아가는 방향을 모색합니다. 함께 누리고 포용하고 참여하는 인권특별시 서울.
Music always embraces an era. It holds the time, space, and scenery of the city that we love.
is a truly special city. This trail is an old railroad track that instead of being torn down, was completely reformed. The city has created a sense of ease and romance I had forgotten, and it surprises me every time I experience it.
You see? What another perfect reason to stay.
I moved to Seoul and now live and work here. I was very impressed with this culture that maintains original aspects while adding a new sense.
It's because empathy is what matters. People-centered values that prioritize the happiness of everyone are found across Seoul, where past traditions and the present coexist.
That warm feeling. Isn't that a great reason to live in Seoul?
I think Seoul is filled with more energy than any other city. Such energy becomes the possibilities of the future. Various attempts to connect individuals and businesses create new business opportunities, and it makes Seoul a city where creative investments are possible with advanced 5G technologies.
More dynamic,
More refreshing.
And more passionate city.
Seoul, a special city for you and me. I saw you. A city filled with joy. A city dedicated to its people, where past traditions coexist with the present. A city filled with creative business opportunities. Seoul, a special city for you and me. I saw you.
네, 여러분 안녕하십니까?
Welcome back.
2020 서울 인권
2020
컨퍼런스
Seoul Human Rights
참석해주신 모든
Conference.
여러분
Thanks for
반갑습니다.
joining us.
네, 저는 오늘 두 번의 일반 세션에 이어서 오늘
I am
마지막 일반
MC for
세션까지
today's
여러분들과
general
함께 하게
session.
된 아나운서
My name
박선영입니다.
is Park Sun-young.
반갑습니다.
Good to see you all.
네, 여러분들 오늘 이렇게 여러 인권 분야 전문가
All the
여러분들
human rights
모시고 이
excellents
자리에
have
함께
joined
하게
us
되어서
for
더욱
this
의미가
conference, and this
깊은 것
is
같습니다.
meaningful
바쁘신 와중에도 이
that
세계
we
각국
have organized this conference. Experts and the participants from home and abroad, thanks very much for your participation. This year marks the 5th year of Seoul Human Rights Conference. And the grand theme of this year's conference is human rights in crisis and the role of Seoul Metropolitan government. And human rights experts from home and abroad have joined us today for 3 general sessions and 3 special theme sessions. For today's general session, we talked about the universal birth registration for the first session, and we talked about the human rights of the multicultural single-parent families. Due to the COVID-19, all the participants and for the safety of all the participants, we are organizing untagged online conference. It's regrettable that I cannot meet everyone face-to-face, but all the viewers can join us online. So please stay with us until the very end. This conference is being broadcast live on YouTube. YouTube Seoul City channel and the Seoul City official channel. For English, you can watch this conference online. You can choose the language of your preference. And this conference can offer sign language interpretation. Also, on the official website, some people have pre-registered, and we have received some questions from those who have registered in advance. And because this is untagged conference, we cannot take questions at the venue. But on the YouTube channel, you can upload your question and leave it on the comments. And depending on the time we have, we can ask those questions to the presenters and discussants. So please bear that in mind. Lastly, we have a live event for viewers. You can screenshot the YouTube page that you're watching and please upload it on social media with a hashtag and please share it on our official website, and we'll select 100 people to provide coffee voucher, and we ask for your continued interest until the very end. We'll now begin a session on worker safety and human rights. So this is session 3 for general session of Seoul Human Rights Conference 2020. This is for the workers' safety and human rights, and for the safety of workers, how we can prevent outsourcing risks and strengthening of the responsibilities of the primary contractors. And so we hope that this can be a good opportunity to that end. This session will be led by the moderator, President Im Sang-hyuk of Green General Hospital, and also Honorary Mayor of Seoul Metropolitan Governments. He is a president of a Green General Hospital, also the Honorary Mayor of Seoul. He is also the member of the steering committee for the Workers' Association. And he will lead the session, so moderator, the floor is yours. Nice to meet you. I am glad to be here at the session for the workers' safety and human rights for Seoul Human Rights Conference. My name is Im Sang-hyuk. I'm the moderator for this session. All the participants who are joining us online, thank you very much for being with us. We will have the session first of all, we'll have the presentations by presenters, and we'll have discussion by the panelists. There will be Q&A session And based on the questions we uploaded online, if we have more time, then we will set a specific theme to have a more discussion on that. I'll introduce all the presenters and discussants. We have a first presenter, Secretary General Han In-im from the Center for Workers' Health and Safety. Next presenter is a certified public labor attorney, Yoo Sung-kyu from labor law firm Chamta. Also, we have discussants and panelists. We have a senior research fellow, Park Jong-sik from Korea Labor and Society Institute. Also, we have assistant professor Kang Tae-sun from Samyang University. We have a senior research fellow Kim Jong-jin from Korea Labor and Society Institute. We have a secretary Cho Sung-ae from Workers' Union Occupational Health and Safety Department. Lastly, we have the team leader Moon Sang-kyu from the Seoul Metropolitan government, who was supposed to join us, but because of the COVID-19, he's being isolated for self-quarantine, so he will join us online. We'll have 5 discussants, and then we'll receive Q&A after that. I'd like to ask you something, because this is a YouTube live session, and if this is not fun, then people will just turn it off. So it's really difficult for participants to stay online. So maybe you can make it more fun. Although this is a heavy topic, but let's make it more interesting. First, we'll have Secretary General Han In-im from the Center for Workers' Health and Safety.
Nice to meet you all. My name is Han In-im. I'm the Secretary General of the Center for Workers' Health and Safety. I'm going to talk about the outsourcing of risk. One of the key issues when it comes to workers' rights is risk outsourcing, in my opinion. I understand that the regular National Assembly ends tomorrow. I'm not sure how that discussion is going to turn out, but the most heated debate currently is it concerns serious disasters and where the accountability lies. And people are raising opinions that we have to ramp up the punishment on the people who are responsible to prevent such disasters. And risk outsourcing is another very important topic alongside this that is putting many workers under risk. At this moment, in front of the National Assembly, many people are holding a demonstration requiring the National Assembly to pass the Serious Disaster Company Punishment Act. But the risk outsourcing issue is a very sensitive and thorny issue that we have trouble dealing with. So today, I hope to touch on this topic in my presentation, since it's a very key issue when it comes to human rights and workers' rights. So outsourcing of risks, or risk outsourcing, means that a risk that existed inside is externalized. So there are not that many research that has done a deep dive into this topic since 1996. Well, I chose the year 1996 because there were 2 big economic crises in the modern history of Korea. There was the IMF bailout in 1997, and in 2008 there was the global financial crisis. So after overcoming those 2 crises, I believe IMF necessitated a fundamental shift or change for the Korean economy. And in 2008, it was relatively a smaller crisis for us, but still the companies had to revamp their fundamental structure. So I think these two occasions or crises impacted our economy greatly. So if we take a look at how the Korean economy changed over time since 1996, as the theme indicates, the number of companies is increasing greatly, but the size of the companies is shrinking. Especially from the IMF onwards, the size shrank significantly. These days, it seems like they're growing in size, but if you look at the number of companies with more than 1,000 employees, the number is dwindling. It is increasing slightly, but it still didn't go back to the previous level, the pre-IMF level. And you can clearly see that the number of companies with around 100 to 300 employees is growing constantly. This means that although the Korean economy has grown in size over the years, the companies are shrinking, which means that they're being split into smaller organizations. They're either splitting off, or they're being outsourced into another company, or they're becoming subsidiaries. The companies are splitting them into different pieces because of many reasons, for resource management. And one of the main causes of this is to outsource risks, especially when it comes to irregular workers. By irregular workers, there could be directly employed irregular workers and indirectly employed direct workers. Directly employed irregular workers are either part-term or daily workers. Indirect employment refers to outsourcing or dispatched workers. So this is well, I did not have enough time to find up-to-date statistics, so this has been quite a while. It's figures that were released in 2015. If you look at the portion of irregular workers and regular workers in the private sector and the public sector, you can see that the share of irregular workers is smaller for the private sector, which is very shocking. And moreover, from 2005 to 2011, if you look at the trend, the share is increasing for private companies with more than 300 employees. This means that although the public sector or public agencies should be setting a prime example, they're actually leveraging more irregular employees. This is not because of economic reasons. Well, I would like to bring up the trickle-down effect here. The government agencies should be showing us a very good precedent that we should model after. And the Moon Jae-in administration has indeed announced that it would address this problem of irregular workers and convert the irregular workers into regular workers. And this is also figures that are quite old. According to recent statistics, out of the total number of wage workers, the indirectly employed workers take up 17.4%. However, this figure does not include outsourced work, whether it's because of risk outsourcing or because of another reason or because of tax evasion. Anyways, all that aside, outsourcing and subsidiaries are not included in this figure. And it does not also include exclusive subcontractors that only service to one company, like call centers. It doesn't reflect the change fully. So this 17.4% does not include all of these companies. So if we take that into account, the figure is going to jump greatly, implying the scale of outsourcing. Why are companies increasingly outsourcing? There are research and surveys as to why this is the case. Conventionally, outsourcing was introduced to source professional technologies or expertise from an external party when the primary contracting company did not have that expertise. That was supposed to be the original purpose of outsourcing, but outsourcing nowadays is conducted because, well, according to the Occupational Safety and Health Research Institute, if you outsource risky and hazardous work, you don't have to take that risk. So 40.8% of the companies answered that they are outsourcing services because of this very reason, to avoid the harm and the risk. And the other reasons were because it's cheaper, the level of the wage is lower, so 28% answered that that was a reason, and 15.5% answered that this was a way to minimize labor and management conflict. But still, we can see that the lion's share is being outsourced because the companies are bluntly not willing to take the risk. Whether if it's going to be they're not willing to make investments into humans or into like finances because they want to avoid that risk. And this outsourcing of risk is being translated into a production of risks because many research has proven that increased outsourcing increases the risks for workers. Of course, irregular workers are exposed to a higher risk. 12 times higher mortality rate, I believe. So this was proven through research, and this is a figure released in 2017. You can see that the mortality rate for subcontracted workers is almost half of the total number of industrial accidents, deaths. And it's very important to note the direction of where this is heading, where this outsourcing trend is heading. It's very difficult to draw a clear line, but of course, outsourcing plays a role here, but the smaller the size of the company, the higher the risk or the mortality rate, especially when it comes to diseases. The figures for diseases does not fully reflect the reality, but in the case of deaths caused by industrial disasters, there's no way of concealing this, so the figures are quite clear and straightforward, and it shows that the smaller the company, the higher the death rate. And this is one of the outcomes that this increasing trend of risk outsourcing has created. As I mentioned briefly earlier, the public sector is currently leveraging more irregular workers compared to the private sector. And in order to resolve this problem, the Moon Jae-in administration has announced that it will convert the irregular workers into regular workers, and 3 years has passed since then. Some stakeholders have now finished their discussion on this conversion, but many of them have decided to establish subsidiaries rather than directly employing employees. But becoming a subsidiary means that you depend heavily on your parent company or the primary contractor and the work that's entrusted by the parent company. So once again, this begs another question as to whether this is a fundamental solution. A representative case in point is Seoul Metro, which is one of the agencies under the Seoul Metropolitan government. There was a tragic incident where a worker, Mr. Kim, died while trying to repair a screen door at a subway station. This is a very important precedent that we have to discuss. Screen doors were installed in all metro stations in 2010 in Seoul, and this work to maintain and repair the screen door was newly introduced. And back then, subway line number 1 through 4, and 5 through 8 were entrusted to different agencies. So what's interesting here is that for line number 1 through 4, the directly employed workers were in charge of maintenance, and during the same period, for line 1 through 4, the work was outsourced, and for line number 5 through 8, it was maintained by directly employed workers. And then in 2012, 2015, and 2016, there were incidents that resulted in the death of a contracted worker, and what's noticeable is that all of those tragic deaths occurred in line number 1 through 4, and there was not a single incident, a death case, in line number 5 through 8. Back then, the late Mayor Park was the mayor of Seoul back then. He was very shocked by this figure, and he ordered that all of the work that was outsourced for line number 5 through 8 was brought back in and conducted by the directly employed workers. So we realized through this incident that these tragic incidents are occurring because the risk is being outsourced when we have been able to prevent it if the work was not outsourced in the first place. Likewise, there was also another tragic incident of another Mr. Kim, who was also a contracted worker and died while trying to repair a power plant. This maintenance work was also something that was conducted by regular workers of KEPCO, but it was later outsourced, and Mr. Kim's tragic death was also brought about because of outsourcing. So in the year before last year, a law nicknamed Kim Yong-gyun, which is the name of the late worker Mr. Kim, was proposed, and the details of the law is to improve the current act, which says that you should not outsource harmful work, and if you are trying to outsource harmful work, you have to obtain prior approval from the Minister of Labor. But the scope is overly restricted, and the people who are entitled to the protection is very limited, so we were aiming to expand the scope of this. If you were intending to outsource work that is risky, dangerous, and should be conducted frequently, you have to acquire approval. So all the work that is listed here are the most hazardous work that led to the highest mortality rate over the years, and that large conveyor belt part specifically has to do with the late Mr. Kim Yong-gyun. People keep saying that the Kim Yong-gyun Act doesn't actually prevent the potential Kim Yong-gyuns in the future. So I do believe that the proposed bill has to be enhanced further to prevent these industrial accidents more thoroughly. And regarding this issue, the National Assembly has to approve an amendment of the law to introduce this change. So what can the Seoul City Metropolitan government do? When I ask myself this question, I can say that there are many Seoul City public institutions that are outsourcing the risks. They're mainly doing it in the form of subsidiaries, so I'd like to say that we need a complete investigation into this practice. And then when we turn to the private sector, can the local governments and central government oversee what the private companies are doing? I actually think that the authority that local governments carry is quite significant. They have the authority to give out approvals, which can come in very handy as a penalty. So One way is to establish a safety work standard contract for outsourcing and try and implement that and oversee whether if the companies are complying with those standards. We recently did a survey with call center operators because there were many community outbreaks of COVID and so forth. When I went onto the site, I saw that the environment was very poor, and I think regarding these operators and other precarious workers, the Seoul city should establish a standard contract and have all of the primary contracting companies of the call centers abide by the requirements so that they would be able to enjoy welfare benefits and other workers' rights as well. Especially, this includes the exclusive contractors of many companies. So with that, I would like to close my speech. Thank you for listening. Yes, thank you, Secretary General Han, for your insightful speech. She talked about the outsourcing of risks, and she highlighted the fact that outsourcing these days is taking place not because the contracting company is best in doing that work, but simply to avoid risks and harmful work. And as they're outsourcing this risk, the primary contracting companies are trying to escape and avoid accountability for any accidents that may occur. So she pointed that out clearly, and she also mentioned that Seoul City should refrain from outsourcing risk like this and come up with many plans to prevent risk outsourcing and address this common problem. Thank you for that. The second presentation will be delivered by Mr. Yoo Sung-gyu, Certified Public Labor Attorney of Chamto. He will be talking about the responsibility of the primary contracting company pursuant to the Safety Health Act.
Nice to meet you. I'm Yoo Sung-gyu. I'm the Certified Public Labor Attorney. I'm going to talk about the laws. So the responsibility of the primary contractors according to the Occupational Safety and Health Net, and what kind of responsibility they have, and why are those problems not being improved, and how can we resolve those issues, and what kind of legal changes should we make, or legal improvements we should make. So that will be the focus of my presentation. In addition to the legal issues, the policy improvements was going to be another focus of my presentation. But recently, I believe that you heard it from the media, but there's a new act on the punishment for companies with serious disasters, and this is a huge topic, and then public interest is huge for this act. According to the current Occupational Safety and Health Act, what is the responsibilities of the primary contractors? I believe that would be meaningful in relation to the new act. So when it comes to the policies, I believe that we can discuss that in the discussion. In my presentation, I'll focus more on the legislation. As you may know, Occupational Safety and the Safety Act was enacted in the 1980s. If we go back to 1981, at the time, the employment system was mostly direct employment, mostly regular employment, and a lifetime employment. So it was a long-term employment. So the companies would worry about the resignation of the employees, so they would pay allowance for the long-term employees. So even the severance pay was accumulation basis. So the longer you stay, the higher the severance pay would be. In terms of the employment structure, the Occupational Safety and Health Act is based on the regular employment and the long-term employment. we have a platform employment and indirect employment, and there are various types of employment. And one of the reasons why the Occupational Safety and Health Act cannot respond properly to those types of employment system is that we still are based on the Occupational Safety and Health Act from the 1981. So we cannot respond to the fast-changing new types of employment. So that is obvious. In 2019, January, the Occupational Safety and Health Act was amended in various aspects, and the target for the protection was changed from workers prescribed by the Labor Standards Act to people providing labor. So the definition was expanded. This is a big progress, and it's a meaningful change. Before, only the directly employed laborers were the target of the act, but this was expanded. But there was a problem. The problem was that there was no content in line with the meaningful change. What it means is that if we were outsourcing the adults at the age of 20 and we were replacing the position of adult by a 7 or 8-year-old child, no hat or no clothes would be fitting for a child if it was a clothes of adults. But we just gave it to a child and asked the child to wear it. If the child is to wear the clothes properly, then we have to actually tailor the clothes. We have to shorten the length. We have to change the size. But we just declared the amendment, and that was it. Was it actually a meaningful change in terms of the content? I don't believe that was the case. My presentation will focus on those points. So let's look into the details. In the Occupational Safety and Health Act, what are the definitions of primary contractors? The word primary contractor is not a legal term. It is just a socially used term. So in the law, the primary contractor does not appear. The people who can be categorized as the primary contractors, there are 4 types. First, independent contractors. As you can see, they refer to employers contracting out the manufacturing, construction, and repair of goods or delivery of a service. What's important here is that here at the independent contractors do not include construction project contractors. It includes the contractors, but not the owners. But in the previous Occupational Safety and Health Act, this was included, but this was separated in the amendment. I'll mention about the problem of this later. The second type is construction project owners. In the past act, this was included as the owner, but now the owner was separated from the contractors, so they have different legal responsibilities. So the project owner has different responsibilities, and the independent contractors have different responsibilities. And legally speaking, independent contractors has more responsibilities, and then they have a stronger punishment if they don't abide by their responsibilities. So when we say construction project owners, many people say, so this is just construction companies. As you can see, it would be to do with IT, culture asset restoration, and firefighting facility. All of these would be included in the definition of a construction project. Unlike the independent contractors, the construction project contractor has a different definition. So the independent contractors cover all different fields, but the construction project contractors is defined separately. So the legal responsibility of the independent contractors is also the responsibility for a construction project contractor, and they have additional responsibilities. And there is other type, including franchise headquarters. So they are not the contractors in the traditional sense, but are a type of employees which in fact be classified as such in that they take labor from workers without directly employing them. So those provided with labor, intermediaries involved in picking up and delivering the goods for delivery workers, and franchise headquarters are included in this category. So what kind of responsibilities they have under the law? So they have these all responsibilities, that they have to designate safety and health head officers. Within the contracted business site, subcontractors work together with the contracted workers, and the primary contractors should designate safety and health head officers. That's the definition. Also, they have to take safety and health measures, and also they have to form a council for the consultation. They have to provide information on safety and health, and when the subcontractors are working at the contracting business site, is considered as the contractors. For the legal responsibilities of construction project owners, step-by-step actions for planning, designating construction, and appointing safety and health coordinators. For instance, if there are two different types of contractors working at the same site, it could incur some accidents, so there should be coordinators who can mediate for the safety and health issues. Also, prohibitions such as action as shortening of the construction period, also extension of the construction period, project period for preventing industrial accidents, also appropriation of the industrial safety and health management cost. Those are the legal responsibilities of construction project owners according to the Act. And the legal responsibilities of construction project contractors, in addition to the responsibilities of contractors, construction contractors has additional responsibilities. So they need to receive guidance and training from specialized institutions in construction disaster preventions. Also, they are prohibited from shortening the construction period. Also, they have to form a consultative council. If you go back to the previous slide, there was also consultative council, but this council is different because this should be comprised of the same number of workers and the employer members. Also, they have to take safety and health measures on machinery and equipment according to the law. Lastly, the legal responsibilities of other types, including franchise headquarters. They are not the contractors in a conventional sense, but they can be categorized as contractors. According to the new amended Act, the most symbolic change is this inclusion of the special type of employees as the contractors. So those that receive labor from non-standard contracting employees are obliged to take safety and health measures and conduct training on safety and health. Also, intermediaries involved in picking up and delivering the goods for delivery workers shall take safety and health measures. Also, the franchise headquarters are also obliged to provide information on safety and health on the facilities provided by them. Based on the details I just explained, compared to the first act in 1981, it may appear that there was a huge improvement. If you see just each details, you can see meaningful changes. But in the beginning, I said that the meaningful change is good, but if this is actually implemented at the work and the business site, and I gave an example of trying to give the clothes of adult to a child. We have to tailor the clothes to be fitting the child, but that has not happened. That's the basic problem. Let's talk about this first. Clarification of the scope of responsibility for independent contractors. The Occupational Safety and Health Act has been amended to expand the scope of responsibility of independent contracts to their business site. And in the places prescribed by the presidential decree that are supervised and managed by independent contractors. So in addition to the business site of the contractors, even if it's a business site by someone else, the primary contractor should still be responsible for the business site. But what does it mean that the places that are supervised and managed by independent contractors being provided by and designated by independent contractors, there's no clear definition on that. So the Ministry of Labor and the court or the police should make a judgment, and depending on the power dynamics between the contractors, the definition can change. This is the abandonment of duties by the law itself. So the purpose of the legislation relies heavily on the political powers and the power between contractors. So the definition may change depending on the power dynamics. So how to improve this? Of course, the definition of the place that are supervised and managed by independent contractors being provided and designated by independent contractors, this should be clarified. Secondly, materialization of the responsibility of independent contractors. Of course, now the primary contractors are given the responsibility, but as you may know, when it comes to details of the responsibilities for the primary contractors and the responsibilities of the subcontractors, when it comes to the qualities of the responsibility, there is a differences. But the law just made an announcement saying that primary contractors should be responsible for everything. Of course, because of the details of the law, if the primary contractor set up a plan, that would be the most desirable, but they are not doing that even for their direct employees. How can we do such act for subcontractors? How can we come up with such thorough plans and implementation plans? There is a responsibility of the law. It should provide guidance and suggest a direction, but none of that has been made by the amendment. So the materialization of the responsibilities of independent contractors, this is necessary. Also, reinforcement of the regulations on prohibiting subcontracting. As you may know, there are the types of employment that are prohibited from subcontracting. But for one-off work, the subcontracting is still allowed. Many citizens do not know this. If it's one-off or intermittent employment or work, then all of the regulations on the prohibition of subcontracting would be meaningless. So if it's temporary or the intermittent work, then you don't even need the approval from the Ministry of Labor for subcontracting, because this is a temporary or the one-off or the intermittent work. The primary contractors can avoid the law or the punishment. So we need improvement of the law in this field. Then reinforcement of the responsibilities of construction project owners. Of course, the construction project owners' responsibilities have been eased, and there are many reasons. For instance, if you are running an ice cream factory and the ice cream factory owner should not be responsible for the construction work for the ice cream factory. The president of the exhibition or the museum should not be responsible for the construction work for the museum. That's correct. But if it's a key construction area, then even if it's just a owner of the ice cream factory or the president of the museum, I believe they have to have a legal responsibility as a primary contractor. According to the Ministry of Labor and Employment, they were going in that direction in terms of the administrative interpretation. So they were going in the direction to strengthen and reinforcing the responsibilities of construction project owners. And then amid all of that, the legislation was amended, and it was almost wavering the responsibilities of the project owners. Of course, there are some areas where we should ease the responsibilities of construction project owners, but there are other fields we shouldn't do that. So we have to differentiate different fields. So we have to return some responsibilities to construction project owners and leave some other responsibilities for the subcontractors. Next is intensification of protection for non-standard contracted employees. the protection scope has been expanded by the amendment, but it is according to the law, Occupational Safety and Health Act standard should be applied. But this is applied focusing on the directly employed workers. So this is the same case. We have given the workers to wear clothes that would not fit them. If you see the regulations of the Occupational Safety and Health Act and other sub-legislation of the Occupational Safety and Health Act, we should include more detailed and new provisions to supplement the new amendment of the Act. Another thing is the new regulations on new forms of indirect employment. More than you know, there are more types of very irregular and new types of employment. If you go to department stores or supermarkets, there will be many of them. They are in-house rented stores, and many cases direct sales or by the big companies would be involved. So for distribution companies such as department stores or supermarkets, would be included in the new forms of indirect employment. So there should be a legal system or facilities that would force the employers to be responsible for the indirect employment. Lastly, intensification of punishment for contractors. You may see in the media a lot of news on act on punishment for companies with serious disasters. If you see the Occupational Safety and Health Act, the punishment would be only a slap on the wrist because it's based on the punishment of the actor's principle. So the punishment would be imposed on those who are involved in the action. When it comes to the investigation and the ruling under the Occupational Safety and Health Act, only those who are actively involved in the action would be punished. But the actual decision is made by the owners and project owners, and they can escape from being responsible for this. And the intermediary managers who are powerless would be punished. And even the punishment level is very low. This system or structure of the punishment should be fully revamped, and we need a legislative change for that, including the act on punishment for companies with a serious disaster. We need more large-scale changes. Otherwise, it'd be difficult to change the punishment for the contractors. Lastly, I'd like to talk about the roles of the Seoul Metropolitan government. I'll spend just 3 more minutes. First of all, there is an ordinance by the Seoul Metropolitan Government on Occupational Safety and Health Act. This is an ordinance that went through very difficult procedures, and it has really good content. But all of these details are not being fully implemented, and that is our reality. Seoul Metropolitan Government went through many difficulties and its own ordeal, so I understand that. But this ordinance, when it comes to the actual implementation and supplementation, if that is done properly, then the issues that we dealt with, the responsibility of primary contractors, can be strengthened and reinforced. Secondly, there should be a system for the management of a public project. Under the Seoul Metropolitan Government, there are so many public projects, and it should have a responsibility as a project owners, and it should be responsible for those projects. So, as a primary example of the project owners, it should fulfill its responsibility, and that would be necessary to bring about the new changes in the private sectors and our industries of the country. And you can see all detailed measures in the screen in my slide. Lastly, resolution of the blind spot in the labor safety and health. Traditionally, when it comes to employment and labor and industrial safety and health, it has been the responsibility of the central government. But R&R has not been adjusted completely, and if the Seoul Metropolitan Government jumps in without any adjustment, it could incur overlapping cost or overlapping R&R. So So metropolitan government should focus on the blind spots that cannot be covered by the central government or other local governments. I think that's the beginning of the role that the Seoul metropolitan government can cover. So this would include irregular workers or other systematic changes would be the more details that the Seoul metropolitan government can play. That's it for my presentation. Thank you very much, Mr. Yoo Sung-gyu. Secretary General Han Im mentioned about why we should not outsource the risks, while Attorney Yoo Sung-gyu talked about if we are to outsource the risks, what kind of responsibility should primary contractors take, and how can we manage the responsibilities? The viewers, for those of you joining us online, there are 4 types of contractors. When we say contractors, if you go to Hyundai car plant, you have different types of companies who are cooperating together. So even if you're working at the same Hyundai car factory, you'd contract out some of the works and outsource the works. So the project owner would be Seoul metropolitan government. For instance, if we are to reorganize the Seoul Square, then the project owner could be Seoul metropolitan government, and Seoul metropolitan government would be responsible for that. For instance, if the Hyundai construction company is in charge of the construction work, then the Hyundai construction would be the the contractor. Also, it could include major department stores for the rental contractors. So they could be the primary contractors. So they have their own responsibility as primary contractors, and they should be responsible for certain areas. So that was explained in detail. Maybe it'd be more difficult for online viewers to understand, but if you replay this presentation, it would be of a great help for you, and it's an excellent presentation. He made some good proposals for Seoul Metropolitan Government. The team leader, Moon Sang-gyu from the Seoul Metropolitan Government, will probably answer to some of the stuff that was mentioned. I hope to see that. We had 2 speakers, and we have 5 discussants joining the discussion. For discussion, the topic is the outsourcing of the risks and the enforcement of the responsibility of contractors. So those are the 2 themes for discussion. And by each industry, we can talk about these 2 topics. So the manufacturing, construction, private service, or the public services. So we can divide into different sectors in different fields, and we have invited experts in each field as discussants. For manufacturing, the outsourcing of risks and responsibility of contractors, we have research fellow Park Jong-sik from Research Institute for Social Sciences. The Research Institute for the Labor is in Sejong, but he lives in Ilsan, so he has to commute via KTX every day. Well, that was really not relevant. Anyway, let's invite Dr. Park Jong-sik for his discussion.
Yes, thank you. My name is Park Jong-sik, as introduced. I was asked to talk about the manufacturing sector, specifically risk outsourcing in the manufacturing sector. Do I have 10 minutes, or how much is the time allocated to me? So in the time given, I'll discuss the manufacturing sector and the outsourcing of risk that is taking place in this sector. In a way, we have a long but short history of risk outsourcing in the manufacturing sector, because the relation between the primary contractor and the subcontractor has existed for quite a while, where the conglomerates or chaebols outsource their work to subcontractors and try and produce products and services outside of their company. But in the 1980s, this wasn't so common. But after the 1990s, especially in this period, we saw companies more frequently outsource their functions externally and try and produce products and services outside of their company, and it grew exponentially from the 2000s onwards. As a matter of fact, until the 1980s, we were not in a situation to discuss outsourcing in full swing. But from 1990s onwards, it is not that outsourcing did not completely exist before that, because historically, especially in the shipbuilding industry, outsourcing had been used, but it was much less frequent before the 1990s, and the nature was also different, because back then it was conducted to source expertise. When you do not have experts in that sector within the company, you have to source them from outside. But from the 1990s, yes, the characteristics started to change, and the labor and management relation also played a role here. In the 1980s, many labor unions were formed, especially in the manufacturing industry. The workers in large factories started to forge labor unions, and outsourcing started to grow in volume. So that's one trend that we also have to note. But anyways, ever since outsourcing began in full swing since the 2000s, it's now become very common, not only in the manufacturing industry, but also in the service sector as well. Department stores, logistics, and in many service areas. Hyundai Motors was brought up as an example earlier, and there was also the shipbuilding companies, and this triggered many issues because at first they started to outsource risky, dangerous, and messy functions to the subcontractors. And people started to voice concerns regarding this practice. But despite that, as I mentioned earlier, the strategy or the nature of outsourcing started to change from the 1990s onwards, and the labor unions, in a way, they embraced the change silently, and this sparked this new trend of outsourcing as a new strategy. And I think in a way the Korean economy kind of lost control on this, because there were no laws or regulations regarding the matter, and the chaebols and conglomerates, they were really seeking to leverage outsourcing as a strategy to grow their company, but the local governments and the central governments did not have tools to control them, so there was a mismatch here. So although this started off as a way to cut costs or to source contingent personnel, but at one point it got really distorted, and companies started to end up outsourcing dangerous work and harmful work. And in the meantime, at first, outsourcing started to become very frequent in the steel industry and the shipbuilding industry and the automobile industry. But then the society started to recognize the problem and introduced some regulatory tools, and there were also criticism raised in one part of society. So there were efforts to prevent this risk transfer to the subcontractors. But still, there is a problem here because you all know the problem of unfair trade and the primary contractor putting unfair pressure on the subcontractors and them trying to transfer this risk to them. Risk here not only refers to industrial accidents, but also managerial risks and labor and management risks and so forth. They try to transfer all types of risks, and we're not doing enough to prevent this. However, as I mentioned earlier, we're trying to regulate such unfair practices. So if there's the primary contractor and the subcontractors, they're commonly called partner companies. Regarding the standard relation, we have made many achievements in regulating them to prevent industrial accidents, and now the companies are scared of their reputation being damaged, so they're making efforts to prevent accidents on the part of the subcontractors. But recently, what has become a problem is the manufacturing companies these days are trying to outsource a function, arguing that it is a temporary or intermittent work. And these cases are becoming more and more frequent. So, for instance, I'm sorry for bringing up the name of a specific company, but anyways, there was a steel company that was trying to replace their conveyor belts. This is actually a work that is required throughout the year, but it's not that you have to work 25 days, 22 days, a month trying to repair the conveyor belt. And for instance, in the shipbuilding sites, if some constructions were delayed because of heavy rain and you sometimes have to source personnel temporarily to repair facilities, they're trying to outsource this function as well. And these cases are becoming increasingly frequent. These jobs that are not technically standard work or functions are being outsourced. And since they are in a unique form somewhat, the supervision on these subcontractors are not being conducted properly. So as I mentioned earlier, amidst these circumstances where the companies are trying to transfer their risk to the subcontractors, in the 2017 and 2018, Mr. Lim and I have put our heads together and tried to craft ways to prevent contracting and subcontracting. But since we're constantly engaging in these discussions, in the past, the portion of subcontracting was only 20 to 30%, but these days the volume has spiked to 60 to 70%, and still supervision on safety and health is not being conducted meticulously. At first, when the function is first initiated, they try to conduct health measures, but the problem is regarding the follow-up measures. The regular safety and health training is not provided appropriately. In a way, laws and regulations or institutions also have to follow the reality. If there is a change in the contractual relationship on the field, the institution has to reflect that change and have to be amended as we go along. But this industrial structure or the change in the employment structure have to be noted, and we have to keep track of the changes on the field, but this is taking a while and we're lagging behind quite a bit. So I think we have to try and catch up with the reality as fast as we can. And I understand that Seoul City is Seoul City is home to many small manufacturing SMEs employers with less than 100 or 50 employees. And in a way, this city is lagging further behind in terms of laws and regulations in this area. So we're in a situation where we have to try and address these issues that have been existing for a long while now. So I think it's time for us to remind ourselves of the original spirit. And one way, as was mentioned earlier, could be holding the primary contractor more responsible. And another way is to try and enhance our laws and regulations and guidelines put forth by the Industrial Safety Health Institute and the relevant authorities. If we don't do that, just because we force these standards on the companies, it won't necessarily translate into a higher level of worker safety and health. So I think we have to build awareness among the general public here. Thank you for your comment. I just cannot help but ask this question. So, according to what I just heard, you're saying that risk is being increasingly outsourced, subcontractors are being more and more frequent, and the work that is outsourced are the so-called 3Ds, dangerous, dirty, and difficult. And this has led to a higher mortality rate on the subcontractors' end. The primary contractor, while outsourcing such dangerous work, can we hold the primary contractor more responsible so that they will improve their practices while still outsourcing the work? If they can't help but outsource the work, we should at least make them put in more effort to prevent the risks, right? Yes, of course, that's one way to address this matter. But I just forgot to mention one thing. The conglomerates, the primary contractors in Korea, so far have been trying to outsource the functions primarily to cut costs, so they are not willing to do anything that might incur more costs for them. They're not willing to attempt that. So, for instance, from the legal and economic perspective, most solutions that are used to reduce industrial accidents end up increasing the cost burden for companies. So these companies end up putting a greater cost burden on the subcontractors, or we have to try and inform the companies and let them know that preventing industrial accidents is actually a way to save costs at the end of the day. Well, thank you for your comment. The second panelist is an expert in the construction industry. As you well know, on average, 2 construction workers are dying every day, mainly because of a fall from a significant height, which is very unfortunate, but we have to try and prevent these tragic accidents as much as possible. If we prohibit the outsourcing of risk, will we be able to fundamentally prevent such tragic incidents? Professor Kang Tae-son, we will provide insight on this very issue.
I am Assistant Professor Kang Tae-son of Semyeong University. Outsourcing of risks and enforcement of the responsibility on the Occupational Safety and Health Act were presented by 2 speakers. The phrase outsourcing of risks was being used earlier, and I actually looked up this phrase on the internet, and based on the articles that I could find, The first article was related to the previous head of the trade union, and that was the first time that the outsourcing of risk was used in the media. Issues related to outsourcing of risks was peaked in 1994 and 1995. This term was used a lot during this time. You may remember at the time the demolition of Sampung department store and the Sangsu bridge also fell. So the risks of outsourcing and subcontracting was dealt with a lot in the media. So outsourcing of construction and subsequent risks were recognized as a big issue in the early stage, and there was some improvement in the system, and we have a new responsible supervision system introduced. After that, we have those people who participated in the construction field without any licenses, and a new law was established to force them to have a professional construction license. So there was improvement of the system at the time. With the improvement of the system, we could promote and improve the safety. But if you see the details of the law, it focuses more on the quality safety and standard safety. So the users of the construction workers and safety of the quality for them were the main focus. But the worker safety was not the main focus. Of course, because this was covered by the Ministry of Land and Infrastructure, maybe that was the reason. But the quality safety and the worker safety can be promoted and improved together. But there was no consideration for that, especially when in the stage of the designing, safety promotion and safety improvement could be actually dealt with by the Ministry of Land and Infrastructure, but that was not the case. Those who design the construction work or the architects, how much of laborers do they consider? I want to do my own survey. There are many internationally renowned architects. The process of constructing those works is actually really poor environment for workers. The issue of outsourcing in the construction field has been pointed out many years ago, and we've talked about that, and there was discussion, but the main focus was the quality safety. Occupational Safety and Health Act was not fully developed at the time, but outsourcing, can we resolve this outsourcing risk issue by converting irregular workers into regular workers? I don't think that's going to be possible in the construction field. Some workers, of course, we need regular workers even at the construction site. For instance, tower crane or the heavy machines at the construction site would lead to a large-scale disasters, and that happens quite often. But many experts say that in the past, as the cause of the disasters, the divisions that would manage those heavy machines, this exists in large corporates. But after the Asian financial crisis in the beginning of 2000, those divisions or departments disappeared, and mostly the lease business entities would take that duty. So because those departments does not exist at the large corporate and the business side, nobody really understands those heavy machines. So the officer in charge of the safety or the health would just look at it, but they cannot really fully responsible for the safety or the health in using those machines. So the experts point out how the lease business entities taking over the responsibility of those works. I believe that's reasonable, and we have to have a proper investigation, and we need to return to the previous system. For tower crane, I believe there was some amendment to the law. I don't know it's going to be realistically effective. We need to see that in the future. For laws and regulations, of course, whether it was the enactment of the first act in 1981 or the amendment in the 1990s, of course, it is important, but we should not obsess over it. There can be something more important. Because for construction work safety, about 80 to 90% of those construction workers would belong to small and medium-sized companies. And to manage these companies, the implementation is more important rather than the content of the laws and regulations. The implementation officers and the budget for implementations are important variables. Also, there should be supervisory strategies. So to fulfill the purpose of the laws and regulation, there should be mid to long-term efforts made. Also, there should be effective replacement of the resources. But the Ministry of Labor and Employment and other affiliates are not able to implement. It is not their issue or their capability issues. Rather, the administration should empower them for their authorities. For instance, there should be an agency in charge of the implementation rather than the act itself to reduce the side effect and facilitate the implementation of the Safety Act. But the amendment he's actually proposed at the National Assembly, but is not going anywhere. Also, as of now, the work supervisor is at the construction site, but if there's any serious disasters, there's any investigation by the police. But even if we have this act by the police or the legal system to raise the litigation, there will be the special investigation authority. So the prosecution office will have a huge responsibility and authority. When we have industrial accidents which would cause the death of laborers, there was no proper investigation, especially if it's regarding the corporations, and the corporation should be legally responsible for the project, because the corporation would be responsible for the cost of the construction site, but no proper investigation has been made for this corporation. And that would be to do with the prosecutors, but prosecutors do not have any expertise. They don't have any sense of responsibility whatsoever. So in this situation, no matter how well the law is amended, it would be meaningless. So even with the current act, I believe that if we can effectively utilize the strategies for the supervision, we can enhance more expertise. And with the new system for the specialized prosecutors, we can utilize the current act. And without introduction of all of these, and we can't really help with even with the amendment of the act. In the construction field, and actually half of the serious disasters happen in the construction field. For corporation, the penalty of 1 billion and under has been included in the act, but no corporation has been actually punished for a fine. But this fine under 1 billion can be imposed for any serious disasters. But what's more important here, rather than the safety net, is the safety organization or the plan for occupational safety and health, and the corporation should be responsible for that. When they do not abide by the law, it could lead to even a bigger disasters or accidents. But the 1 billion penalty or the fine is applied to certain activities by the corporations or certain actions by the corporations, and this is completely wrong understanding of the causes of the accident. So I believe we need amendment of the law in that regard. In the construction field, subcontracting and the primary contractor's responsibilities, the new amendment is quite meaningful when it comes to that, I believe. But when it comes to the project owner's responsibility, I think we did have some improvements. Before, the less than 2% of the safety and health expenses were the responsibility of the project owners. That was it. Now they have to complete the saved ledger at the site, so they do have more responsibilities now. So they now have at least a sense of moral responsibility, and they should also be able to oversee what are the risk factors. I believe that this is only a starting point, and we should enforce more responsibilities and make it more detailed in terms of the project owner's responsibilities. And we should raise more issues regarding this. For discussion, lastly, I'd like to mention briefly about the manufacturing field. The presenters focused more on the manufacturing sectors, so I'd like to briefly touch on that. Outsourcing of risks, of course, after 2011, there was a discussion and questions raised by manufacturing sectors whether this can be resolved by transferring the irregular workers into regular workers. I am doubtful. Of course, the outsourcing could be the risks because those contracted laborers or outsourced laborers would be cheaper. But if it's the same labor and the same cost, can you actually make a decision to turn the irregular workers into regular workers? Why are we not connecting the labor issues into the cost? And why do we keep enforcing companies to regularize the workers because of the safety issue? I believe we need to separate the issues. By enforcing the responsibilities of primary contractors, I believe that we can reduce the outsourced risks issue. Even if you outsource the risks, then the primary contractor should be responsible for the risks, because for legislation we have to implement. Of course, subcontracting law may be easy to implement, but implementation is difficult. We have approval system, but after approval, the responsibility of a project owner would be responsibility of a public servant, and even the procedure is not easy. So this would cause a huge chaos in the site, and the public servant would take all the blame, and this is not reasonable. The project owner should be responsible, and that should be maintained. I believe we have to ask for the cause of the cause, and for the safety of the labor, we need to separate certain aspects from each other. For instance, there is a registration system for chemical substances, so this would not allow a certain harmful substances, chemical substances, from entering the market. So this is completely block new substances to come into the market or being used. And the construction or the manufacturing fields can utilize this act, and this act is currently covered by the Ministry of Environment. So by utilizing all of these laws, we can make the current act more effective. That's my opinion. And lastly, for construction field, we see the largest number of serious disasters, but including manufacturing, we only have investigation, and even for investigation, it only targets the workers at the construction site. So it doesn't give us any lessons. In addition to investigation, I believe that there should be additional system for survey and further investigation. So this is not to punish anyone, but this is to identify the fundamental causes so that we can get some lessons. And depending on the lessons, if the government is required to enact a new act, or the project owner needs to make some improvement, then we can make a recommendation. Also, there could be some improvement that should be made for the same field, so we can come up with recommendations and we can monitor the implementation of the recommendation, and we can complement or enforce them to implement a recommendation depending on the result, and we can disclose the report. But we do not disclose the result. We continue to report wrong causes after the investigation. It was heated issue for a while, but then it happens again, so it's continuously happening. Of course, for the investigation, there should be expertise, and we need a separate survey research system. So metropolitan governments, when it comes to the accident survey, the corporate or project owner should conduct this according to current act. But the Seoul Metropolitan government can be project owner or the investigator, whether under the Occupational Safety and Health Act or under other act. I believe that the survey system can be established, but through this system we can find the causes and we can get lessons and we can monitor the recommendation and its implementation. I think that could be a good option going forward. Thank you. Thank you very much. I don't know how to summarize what you said. You said a lot, but to mention one thing, the outsourcing of risks was probably in the mid-2000s. At the time, I participated at the symposium, and I heard the outsourcing of risks, and I was really shocked. Maybe it was not reported at the media, but anyway, to the assessment professor, I have a question. Lotte Tower is a famous, and then it had cracks on the parking lot, and opening was delayed because of that. And the president of Lotte Group had to apologize to the consumers. While constructing Lotte Tower, many construction workers died, but there was no reflection on that. With the amendment of the law, can we make it possible for these construction workers to be reflected upon? And you talked about the prosecution's responsibilities. Even so, there are many cases where the judge would rule innocence for the project owners. Even if there are 5 or 6 construction workers die, then the ruling would be that no guilty for the corporate. So what's your answer on that? The CEO of a corporation or the president of the group, there is no need for them to apologize, even according to the current act. Those who are in charge of the construction site should be responsible for the accident, and the fine is about 1 billion maximum. So when it comes to those construction accidents, nothing has changed. In the investigation process, the CEO of such big corporate, I don't think it's so desirable for those CEOs to go to prison for that. But in the investigation process, the prosecutor's office can investigate the president of large corporates, but that investigation does not happen at all. So that's the tendency of the prosecutor's office, because they tend to advocate or tend to take a side of the corporate. To investigate the corporate, you also have to investigate the president or CEO, but that doesn't happen. So that's wrong practices that we have deeply rooted. So more proactive investigation should be made, and we should also try to teach this large corporate in dealing with the construction site, but everyone's so busy just to wrap it up. So that's why we keep talking about the implementation or the amendment of the act, or the implementation of the act on punishment for companies with serious disasters. But these large corporates never change, and to make them change, we need a new act or laws. I don't know why these prosecutors abide by law so much when they are about to punish those people in the large corporates. When they are to punish the large corporate, they stick with those laws, but for others, they interpret it in different ways. For the second question, what was the question again? Oh, okay. When it comes to judge's ruling, I believe that's the problem of the Article 29 of the Industrial Act. So if you are found to be innocent, then you'd be exempt from the responsibility. So there were some lawyers trying to make the ruling innocent. So I believe that that would not be the case anymore. Thank you very much. Thank you. Due to the time constraint, let's speed up our discussion. As I mentioned, the industrial structure of our country is shifting from manufacturing to service industry. In service industry, there are many problems and issues occurring. I believe the reason is that the subcontracting and contracting relationship is more complicated and it's more broad. And also the difficult or hard works are all being outsourced, especially in service industry. When it comes to the service workers and their health and the safety, we have the best panelist, who is a senior research fellow, Kim Jong-jin from Korean Labor and Society Institute. So please.
Yes, as introduced, I'm Kim Jong-jin, Senior Research Fellow at the Korea Labor and Society Institute. I was asked to talk about the service industry. Over the past 20 years, in line with the global trend, the industrial composition of the Korean economy is changing. The focus is shifting from the manufacturing industry to the public sector and the service sector. And this change implies that this industry is developing and is accommodating more employees. Another trend is the development of IT, and this is also taken place in the service sector as much as the manufacturing sector, bringing about a more diverse form of occupation in the service sector. We refer to this phenomenon as the diversification of employment. Fundamentally, just like the outsourcing of risk, there is a subcontractual relationship in the service sector, but it is much more complicated and convoluted than you think. Thirdly, the service sector compared to the manufacturing sector, vis-a-vis the manufacturing sector, it employs more vulnerable workers. For instance, the portion of irregular workers is higher, and it employs more women, young people, and senior citizens. These people are exposed to more risks, so to speak. And the fourth characteristic is that the irregular workers are safeguarded by the Labor Standards Act and the Occupational Safety Act until the Occupational Safety and Health Act was implemented and amended last year. But with the amendment, they started to be considered as people who are providing labor, and the delivery workers, they were outside of the scope previously, but has been included in the scope very recently in labor workers, which means that these workers, there are many of them in the service sector, but they're not employees, they're not users, they're just workers in a very gray zone, like delivery workers, the riders who deliver food for franchises, and the drivers. They were recognized as laborers previously, but now they are not receiving that recognition. So these workers, platform workers, have become more vulnerable. And it is a new form of employees that is emerging. It is a form of outsourcing, but they're technically considered as a self-employed person, so their labor security and safety is not being guaranteed. And another characteristic is that Almost half of the death cases for industrial accidents is happening in the construction sector. They're mostly accidents from falling from a height. But in the service sector, there are a more diverse form of industrial accidents, like being parts of the body being severed or caught in machinery. Over the past 5 years, industrial accidents that occurred from motorcycles has increased greatly, and 42 workers have 3,500 people have suffered an injury or death, and around 13 of the delivery people who work in logistics centers have lost their lives. This is because they are subject to a very heavy workload, and they're working day and night and working 14 hours a day, and such an overload of work is leading them to the verge of death. And in the past, there was regulations on standard working hours of workers, but these platform workers are outside of the scope. It's not included in the standard coverage, so they are not subject to the 52-hour weekly work rule and are driven to death. For instance, in order to have a package from company A delivered, that package is first delivered to a hub, and the person who delivers that to my doorstep is not someone that's directly employed from company A. This person is self-employed and is a contractor, special contract worker that signed a contract with the franchise. So this person is technically a subcontractor of the company. So in the service sector, the structure is much more complicated. So the delivery worker is a contractor of the subcontractor, and it's a multi-layered structure which drives them further and further away from the protection that the law provides. These people don't even have time to eat. And according to a recent survey, it was found that these delivery workers only get 30 minutes to eat, and they have to eat very quickly, simple snacks. So when we order through delivery apps, those drivers also work 6 days a week and many hours a day. And they're working so hard because one case of delivery means more money for them. And if they just rest for even an hour, that will result in a significant drop in their daily income. So I've heard that they refer to the delivery calls as the call of death, because they have to risk their life, put their life on the line to earn more money. The theme for today's conference is human rights. A sociologist named Marshall said that the most important right in the 18th and 19th century was the right to freedom. And these days, there's the right to health, right to welfare, right to education, and there's also the sector of labor. But there's this one challenge that we have managed to struggle with consistently, which is the matter of occupational safety and health. So we have to put a stop to this trend of risk outsourcing, the outsourcing of death, and this increase in the number of specially employed platform workers. We have to craft more institutional safety measures for them. I think we're consistently talking about expanding the scope of the legal framework. If you go to department stores, there are people who are selling cosmetics. They're not directly employed people. They're once again the subcontractors of the subcontractors. So there is a triangular relationship formed, and everybody would try and blame each other and point toward each other when there is a unfortunate incident happens. Not the department store, nor the primary, the first contractor, but the subcontractor. Nobody would be willing to take the blame. And I think as much as the manufacturing sector, the workers are suffering in the service sector because of the level of emotion that's involved in providing the service. They are mostly subject to abusive wording, and we have to try and safeguard the occupational safety of the service workers in this industry. Since my work is more since the type of disasters are more diversified compared to manufacturing and construction, I think for this sector we have more factors to take into account. Yes, thank you. When I think of industrial disasters, dangerous chemicals or falls immediately comes to mind, but working extremely long hours, overworking, so to speak, can also be considered a type of industrial disaster, and I just realized that. The standard law specifies that people should only work 52 hours a day, but the workers who are technically not workers end up working endless hours since they're classified as specially employed workers. We only have 17 minutes left, so we have to move forward very quickly. We have been talking about the increasingly severe outsourcing trend in the public sector. And one of the first things the president did after coming to office was to announce that he was going to convert irregular workers into regular workers. Now I want to talk about the outsourcing of risk in the public sector and increasing accountability. I think one of the organizations that is very strongly committed to this cause is this organization where Ms. Cho Sung-hye is working for. So please.
I am Cho Sung-hye from the Korea Public Service and Transport. When I am the final discussant, I always have to hurry up. And then we have one more discussant who will join us online. We talked about the outsourcing of risks, and this is what I want to say. Outsourcing of death, we have to stop it right now. The risks has been outsourced, but the result is that we have more death. Not the regular workers, but the outsourced workers are dying. Not the workers at the plant, but the workers who were outsourced to do the work at the plant, or the non-standard employees. I believe the biggest result of the outsourcing of risks would be outsourcing of a death. I don't know if you remember this, but there was a huge explosion a few years ago, and because of that, the citizens who were passing by died. And a few years later, there was another incident where the worker died as a result. So as a result, the government came up with guidance for public institutions. There are 340 public institutions and agencies. It all varies depending on type, but in total number is 340. But for about 100 public agencies that are prone to have industrial accidents, they are the target of the guidance by the government. I think it is a good thing that they started it, but it is actually being implemented well. Of course, it was a good start, but when it comes to implementation, we need to assess the performance. There are two issues, mainly to be in charge of the safety, there should be manpower and the system. When it comes to system, the guidance provided a clear system. So there should be officer in charge of the safety or executive in charge of the safety. But this is not a new management. So this should be the office of the quality and safety office. So the person who are in charge of the quality is now in charge of the safety. So the safety of the production and quality and the safety cannot go hand in hand because of make preconditions. For the production of this, we need to speed up the process, or for production of this, we have to eliminate certain processes. But the quality and the safety are put together, and the executive should be responsible for both according to current system. Secondly, for public agencies, they say our safety is the safety of citizens. If they actually believe that, they first need to do ex-ante examination. So they have to have a regular examination based on the regular cycle. But the biggest problem or the biggest issue that they complain at the work site is that they don't have time to actually review the situation, so they're busy fixing the problems rather than preventing the accident. But when the accident happens, they do ex post repairing work. That's the most of the work that they do. That's the issue of manpower. Recently, the Kim Yong-gyu Special Investigation Committee had to have a meeting with the Ministry of Finance, and the Ministry of Finance said for the industrial manpower, we don't have enough manpower. And the industrial sites say when they say they need this much of a manpower, they never get enough manpower because the ministry would cut it off. So they have different stories. The safety should be the priority, and then when we talk about this, they say the expansion of the public workers would be a negative point for assessment of the public agencies. For instance, we had 100 people in charge of this, and we need extra 10 people, then it would increase in the labor cost. So when it comes to the public agency assessment, they would get a negative or a lower score compared to other public agencies. So this is distorted system that they have at the public agencies. So of course the guidance, establishment of guidance was good, but to implement it, we need budget and manpower, and that are not being implemented properly. There was also another discussion. Because there are only 340 public agencies, so in addition to the executives in charge of the safety and the quality, we need a separate executive who will be in charge of safety alone. And they said, well, it's not possible because of the lack of manpower. Public agencies are in charge of the 50 million Korean citizens' safety, and they cannot afford the budget for additional 340 executives in charge of the safety. Is this government really concerned about the safety of the citizens? I'm doubtful. It was mentioned by other discussants and the presenters that they say it is a place designated by the contractor. So even under the current Occupational Safety and Health Act, they changed the definition to include people providing labor. Of course, all the workers provide labor. In the coal factory, for instance, a worker was in charge of carrying that coal in their car. They were forced to do the work, and there was a non-standard employee, and this was not covered. This worker is not covered by the Occupational Safety and Health Act. It was not covered by the Industrial Accident Act. So they do provide work and labor, but they conduct work that the contractor should do. But that work comes down to the weakest link, which is non-standard workers or subcontractors. So this is a problem. For the guidance of the safety for public agencies, it required for the railway metro and the manufacturing, all these sectors, they should integrate the subcontractors and contractors. So in the end, it's just power plant and the railway. Whenever there is a new accident, a new addition is added. So if there is many accidents at the nuclear power plant, then they will say you have to have a separate measures. For instance, if there is an accident at the at the gas, then they will be required to have integration between the subcontractor and contractor. Rather, if it's a public agency, I believe they should announce comprehensively the accidents at the contractors level and subcontractors level together. Also, I don't think you can see this clearly, but this slide is used at the special investigation for Kim Yong-gyu. There are many subcontractors at the public agencies because of the expertise and specialties they have. But the people with expertise only dispatch people. So at the power plant or the railway, they cannot replace just one machine. What kind of expertise do they have? I don't think that's expertise. They are encouraged to dispatch outsourced workers by the governments. And to protect the safety of the public sector, the government has come up with a safety grade system, such as grade 1 to grade 5. But what's the standard or criteria for the grade? How much of an investment are you making for safety, or how much of a manpower do you have for safety? It should be additional point and not the negative point. So I believe we need some reasonable system for that. For public safety guidance, there is something missing. We are here at the Seoul City office, all the people working here are the public servants. Just because it is public servants are not included in the guidance and the scope of the guidance. Another thing is that at Seoul City office, there is workers are based on the contracts. They are not civil servants, but they still work for the public agency, but they're not included in the guidance for public safety. In the spring this year, at the Han River Management Office, you can see on the bench or the shade. There is a tent installed for the shade. One worker went up to the tent to clean up, and then the worker fell and then got injured. If it's that high, there should be the vehicle being used for cleaning up the tent, but they've never used it. It was so dangerous work for the worker to go up to the tent. Most important thing in the safety of a public agency is a risk assessment, but this assessment is not being made by the public agency, and I believe this is highly risky. If we are to make proposal to the Seoul Metropolitan government, the government targeted public agencies for the safety guidance, but that scope should be expanded to include public servants. Also, there are many SMEs included in the special project under the Seoul Metropolitan government, but without the trade union, it's difficult for us to actually intervene. So the industrial supervisor system should be expanded further so that we can actually go into the site and check the risks, and we can make recommendations. When the Seoul Metropolitan government was established in the ordinance, we proposed this, but this was not included in the ordinance. So it should be included in the ordinance to create a safer Seoul and safer Korea. Lastly, Seoul Industrial Safety Corporation changed their phrase to "safety is a right." This is such a valuable slogan. Before they focused on how workers should be cautious, now they are saying the safety is a right. And out of the right, the biggest right is the right to not die. For right not to die, this is also based on the right to live and the right for happiness. So I hope that our conference will be a good opportunity to improve those rights. Thank you very much. So we have the last panelist. Mr. Moon Sang-gyu, team leader of the Labor Policy Division from Seoul Metropolitan Government. It's been not very long since he was promoted as a team leader. He's been working a lot for the Seoul Metropolitan Government, but he was worried if that cannot be introduced properly to the audience, so please bear that in mind. Do we have a Mr. Moon Sang-gyu online?
팀장님.
Mr. Moon? Can you not hear us? You should probably, maybe you're on mute. Could you unmute yourself and
우리 진행 요원이요. 이거 어떻게 할까요?
what should we do? I'd like to ask the staff on the site.
예, 참고로 이제 서울시는 아까도 말씀드렸지만
Just for your information, so are we connected now? Seoul City was the first local government to forge a occupational safety and health ordinance. A detailed plan is incorporated in the plan to craft the ordinance, and technically it is the first local government that is trying to declare this plan on occupational health and safety. So, Mr. Moon, are you ready to comment?
예, 잠깐 더 말씀드리면 그러면 저희가 시간 관계상
So, due to time constraints, we will wait for a moment until we hear from Mr. Moon. Please ask him to prepare his comments. And we're receiving many questions on YouTube right now. I'll just try and select some of them and ask them to our panelists. The first question is, sometimes requiring imposing health requirements is considered a personal requirement. In order for this to be perceived not as a personal responsibility but as a social responsibility, we need a paradigm shift. What should the organization and the society do to build awareness on this? Who should be answering this question? Right, so one of the very common terms that we use in the society is this unawareness of desensitivity to safety. I do believe that desensitization towards safety is a very wrong term. These accidents are triggered by flaws and shortcomings in the framework. So if we don't repair or address this flaw in the system, the accidents will keep on happening. So what we're trying to do to address this problem is to, as we have constantly proposed, we're trying to amend the Act on Punishment for companies with serial disasters. There are parts of the society that cannot be redressed with simply the effort of individuals alone. We cannot rely on the voluntary participation of the people alone. We need a legal amendment. Are we ready? Yes, just keep your comments brief, please.
Just to add, of course, what you just mentioned is extremely important. Without changing that, even the systematic change would be meaningless. Such a sentiment or the mindset has been very prevalent in our industrial site, and this is based on the long-term sentiment to blame the individual's mistakes or fault. That was even from 100 years ago. At the time, they had a rotten apple theory in the Western countries. This theory has been abolished in the Western countries, but the mindset of the business owners is the cause of the industrial accident, as it was proven 40 years ago in the Western countries that was spread across the country, across the world. But that is not introduced in Korea. It will take time for us, but we have to change our perspective to see the incident, and that's why the investigation should be more universal. Thank you. Thank you very much. So the secretary Cho Seung mentioned we have to be cautious now. It is a right. So we waited long for team leader Moon Sang-gyu. Do we have him on Jun? If you are connected, please.
예, 안녕하세요.
Yes, hello. I'm the team leader of the Labor Policy Division of the Seoul Metropolitan Government, Moon Sang-gyu. As was mentioned earlier, I'm leading the Occupational Safety Department at the Seoul Metropolitan Government. Our division was first formed at the end of 2019 and was launched in full swing in 2020, and we are trying to lay the groundwork for the ordinance that the Seoul City is currently pursuing. However, the system of occupational safety specifies that the government should take the responsibility for the safety and health of the people, and the local governments don't hold the authority, but they simply play a supporting role in order to address this problem and to create a legal basis for the protection of the private sector and the vulnerables. We began this project, and on November 15th, Member of Parliament Lee Byung-do proposed that we amend the ordinance on the prevention of industrial disasters and occupational safety. So we have now created a legal basis for that. So starting from 2021, we will be able to support the companies that are performing well in occupational safety and health, and we are now prepared to provide the basic support for workers' health and safety. Regarding the details of the ordinance, I will explain in detail when the final draft is published. The effects that we are expecting for this to play is to provide support for the we have secured around 500 million won of a budget to finance companies that have set prime examples in the area of occupational safety and health. It is very important to support companies that are performing very well and the vulnerable workers, because we have to set up this basic framework for support, and the users of the companies, the consumers, should be responsible of laying this ground. And since the Occupational Safety Act provides for that, we have to secure a certain amount of support for the marginalized and the vulnerable as well. That's why we're beginning this project next year. There are many programs that Seoul City has planned, but out of them, one of them involves bullying in the workplace, preventing bullying in the workplace. There is no punitive clause found in the current act, but we plan to establish a basis for that. And to this end, we are currently preparing many educational material. We're also trying to create animated characters and create YouTube contents to create and enhance awareness on this. Since we're now starting to provide support for local governments are now trying to start their support regarding occupational safety and health. We're now taking the first step, and Seoul City is the first local government to launch this effort, but I hope that it would be scaled up going forward, and we will be able to lay a more expanded groundwork so that starting from next year, our citizens would be able to work in a safer working environment, and that monitoring on their safety and health would be conducted more thoroughly at the workplace. So that was a brief presentation. That will be all for my comment. Thank you. Yes, thank you. I think Seoul City would be one of the few local governments with a industrial safety team. And I think it's the only local government that has plans to establish this ordinance and craft plans accordingly, because there's no legal requirement that is specified in the law. It's purely Seoul Metropolitan Government's voluntary effort to pursue this. So we're almost out of time, but we received so many questions, so we should probably answer a couple of them. One has to do with the act on the punishment for companies with serious disasters. The law prescribes that the employers should be punished. Should the government or the local government not be punished? Yes, I think I can answer that.
According to the Occupational Safety and Health Act, the local governments or the central government can be the project owners, but also the users. So they have to fulfill their duty as business owners or the project owners. Also, for the private companies, they should play a managerial role, so they should play both roles. Thank you very much for your answer. I believe that could be enough answer. I don't know who will be the mayor of Seoul. If there's many industrial accidents, then even the mayor can be the target of the investigation by the prosecutors. Next, for the assistant professor Kang Tae-sun, this question directly refers to you. The outsourcing of risks and the enforcement of the responsibility of the primary contractor, this is all legal issues. So for the local governments, they cannot really respond properly due to the reduced authority they have. Professor mentioned that there should be a responsibility enforced, but at the local government level, what are the ex ante or ex post measures that you can take? That would be the last question. For Gyeonggi Province, they argued they won the investigation rights for the labor cases, but I don't think it's possible. I don't know how much of work the local government can do. The disclosure system can be an example. I mentioned about the survey system. Of course, the survey for the project owners, we can give the authority. If that information is disclosed, then it could be an option. More than anything, for the project ordered by the Seoul Metropolitan Government, there should be no deaths or industrial accidents. But if there is an investigation, the result would never been disclosed. So if there is any proper investigation, just as the case for the labor or the worker at the Gui station case, if the responsible team at the Seoul Metropolitan Government can conduct the investigation on the survey and disclose the result, then it would be a huge burden for the corporations, and it would be even a stronger effect than the punishment. Also, for public announcement system, it can be included in the contract. There are many systems that are being implemented. I believe those system has been implemented for 2 to 3 years, and we need to improve those systems because it's not efficient enough. For project owners, if there is any construction or project, there are many projects, and I believe the promoting those projects is important. Also, for the project of those, I believe that there should be MOU between the Seoul Metropolitan Government and Ministry of Labor to make it more reasonable. Even with these measures, I believe there could be great improvements. The government focus on the fall of the construction field. So the half of the project is focused on the construction sectors, but for the Seoul Metropolitan government, they can sign an MOU with the Ministry of Labor after consultation. I believe that could be a great achievement, and there could be some improvement. I believe that is a great burden that you're giving to the Seoul Metropolitan government. When I see Seoul government, I'm always concerned during summer because Noryangjin or Yangcheon district, we always have a flood, so many people die, and it continues every year. So I believe that it should be also investigated, and the report should be disclosed to prevent these disasters. We've had this session for over 2 hours, conference and a general session on worker safety and human rights. It was a difficult and maybe too rigid in terms of the content that we had to deal with. But thank you, everyone, for joining us until the very end, and all the discussants and speakers. Thank you very much as well. So this concludes Seoul Human Rights Conference 2020, General Session 3 on worker safety and human rights. Thank you. Thank you very much. This concludes General Session 3. Thank you very much, Moderator, President Im Sang-hyuk of Green General Hospital, and Hanin Im, Yoo Sung-kyu, Park Jong-sik, Kang Tae-sun, Kim Jong-jin, Cho Sung-ae, and lastly, Moon Sang-kyu, who have joined us online and offline. Thank you very much. General Session 3 was on worker safety and human rights. This concludes Seoul Human Rights Conference 2020, General Session 3. Seoul Human Rights Conference 2020 General Sessions are all completed. All human rights experts have joined us, even some online. All the members of society are entitled to their human rights, and I believe we should be the actors to protect these rights and human rights. This is why this conference is more meaningful for everyone. All the participants, thank you very much for being with us with enthusiasm and passion. For participants who are with us on YouTube, thank you very much for your interest. We hope to see you face-to-face next time for direct communication. So this concludes Seoul Human Rights Conference 2020. Thank you very much for joining us. We hope to see you next year again with more abundant content. Thank you very much.